May it please the lawsuit. My lord, with respect to item number 3, my lord, I am not aware of the case, my lord. One junior Miss MS J. Bola engaged me in 2019, my lord. Neither the file is me, nor she is contacting, nor I do not. I know the client also, my lord. So I,
Wait for some time till we take up the all the matter, because 2019 matters we are compared to past orders after looking at the records. Please wait for some time.
Hello.
May I please, Lodge? In respect of item number
Let
10.
him do his senior to you.
Yes, sir. Yes.
May I please, your lordship? On request of my lord A. Chaudhary, my lord, I want to mention item number 42, my lord. My lord, if possible, my lord, can it be taken up?
It is contempt matter, yes.
Yes, my lord. After motion, if it is possible. Or as your lordship, during the course of the anything.
Okay, we'll do it at 2 o'clock.
Yes, sir. Much obliged.
Yes.
May I please? In respect of item number 10, my lord, I pray for an accommodation today. I'm not prepared to argue the case because of some personal difficulties.
When do you want?
After a week.
What says the represented on the prayer made by the council the petitioner, please start the week.
Obliged.
May it please your lordships. I beg to mention item 41 of today's list, lordships. And I've informed the other side, well, they're here. This matter may please be taken up next week. I appear for the alleged contempt, my lord. I have filed my counter affidavit. I have some difficulty, my lord, today.
Lordship,
If I may please.
against their affidavit, we would also like to file our reply. Lordship, 2 weeks time required, madam. We have to collect some documents, madam.
What says the represented? Both sides pray for adjournment. Mr. S. Chamaria and counsel for the petitioner submits that he has to file a affidavit in reply in the matter. Understands adjourned today. This after
2 weeks, my lord. Some document we have to collect from the bank.
If I may most humbly pray for a date, lordships.
you did.
Deeply obliged, lordships.
whatever was passed in my case on 16 to 2026, my lord, where some necessary correction is there, my lord. The Superintendent of Sunitpur, instead of Superintendent of Vishwanath, the Superintendent of Sunitpur is mentioned, my lord. That is for necessary correction. But I have not obtained the certificate.
Give a mention. memo. Give a mention memo. It has to be listed and brought forward. Give a mention memo. Yes.
May I please, your lordship? My lord, I beg to mention item number 32, my lord. The other side is also there, my lord. This matter may be possible for the day, my lord.
Well, can it be fixed in March, 3rd week, my lord, if not inconvenient?
3rd week.
My lord, first week is Dolutsav, my lord, I will be at my native place. 2nd week, I have some preoccupation.
No, he's asking only for a day.
No.
That's right.
Anyway, my lord, I leave it to your lordship.
Okay, 3rd week.
Yes.
Okay.
Deeply
Both
obliged.
sides are represented on the prayer made by Mr. D.P. Bal and counsel for the petitioner. The matter appellant, the matter stands adjourned today. Is agreed to both sides. List on 16/3/2026.
My lord, my lord.
Obliged, my lord.
Yes.
Lordship, I beg to mention for listing for motion that new case.
Give to the person.
Tomorrow, Lordship.
You don't know, he'll have to adjust.
Please, your lordship. Lordship, with the consent of the petitioner, I beg to mention item 26. Lordship,
26.
yes, lordship. Can this matter be taken up after 2 weeks, lordship?
My lord, date may be fixed, my lord.
Both sides are represented on the prayer made by Mr. D. Upamanyan and counsel and a standing person for the health department.
Yes, Lordship.
The matter stands adjourned today. List on. You would could
Dates on 2nd week, March. Highly obliged.
Lordship, I'm praying for the listing of a fresh contempt case on Friday.
listing get to the court master.
Sorry, Lordship.
Wait, please, Your Lordship. Lordship, I beg to mention item numbers 53 and 54 of the supplementary list, Lordship. Lordship, I bid in a matter may be adjourned for a day, Lordship. We are supposed to file an affidavit. We received the instructions that 2 more weeks' time is required, Lordship.
You inform the other side.
Lordship, I have informed, Lordship. Mr. S. Ahmed, Lordship. Item 53, 54, supplementary list, Lordship.
Both sides are represented. On the prayer made by Mr. Agrawal and counsel for the
Respondent.
state,
of Association.
the matter stands adjourned for 2 weeks to enable the state to file an affidavit in the matter. List on your date after 2 weeks.
May it please your lordships, taking consent from the other side, I seek an adjournment for item number 24.
24. You are for?
For the appellant, sir, Vidya, no, lordship.
Both sides are represented on prayer made by the appellant, the matter stands adjourned today. This long, your date after 2 weeks.
May it please your lordship. I'm praying for a listing of a review petition. Oblige lordship.
May I please, your lordship. Lordship, I beg to mention item 28, lordship. In this matter, lordship, Mr. D.K. Agrawal will argue in this matter, lordship, and he has received some injuries, lordship, and he is under recovering, lordship. So I'm praying, lordship, it may be fixed after 4 weeks, lordship. His hip has been fractured, lordship.
Item 28. Both sides are represented. This therefore adjournment is made on the ground that the learned counsel holding the brief has suffered an accident. Accordingly, matter stands adjourned. Okay. List after. Give a date after 4 weeks.
Deeply obliged.
May I please, your lordship? Lordship, I beg to mention item number 34 orders item 2018 matter, my lord. Last time just order was passed for taking the status report of respondent number 12, my lord. So kindly may upgrade the matter if possible, my lord.
Lordship, with the consent from the other side, I beg to mention item number 19. Lordship, I'm paying for some accommodation on behalf of counsel Mr. S. Thakur. Lordship, can this matter be taken up after 2 weeks, your lordship?
You've taken consent of the.
Yes, lordship, lordship, we are there.
What is represented? On the prayer made by London counsel for the private respondent, the matter stands adjourned today. This one, you will fix date after 2 weeks.
May I, lordship? Lordship, beg to mention item 27, lordship. Some updated instructions are have been sought from the petitioner, lordship. So kind for the day, let me be adjourned, lordship.
This both sides are represented. This proper week is paid for by non-counsel for the petitioner. 27.
Obliged, lordship.
For motion, item 1.
Yes.
May I please, your lordship? My lord, we have challenged the order that is page 50. Here in page 51, paragraph 4, it is seen that the learned tribunal has written a number of documents have been exhibited. Page 51, paragraph 4. And those are public documents, but the finding may be seen page 52.
Yes.
From the above discussion and evidence of the proceeding, are not sufficient, reliable, trustworthy, because she has not disclosed the material facts or proved the proofs with the original. On the other hand, averments of WS are required to be proved by producing and adducing reliable and cogent evidence. Mere submission and exhibits are not sufficient. The truth of contents are to be proved comparing with the original. Failure to disclose the material facts, it creates a serious adverse inference against the proceeding. She could not prove that she discharged the burden of proof under Section 9 of Foreigners Act. Accordingly, she is an illegal migrant and declared the contesting proceeding as a foreigner under Section 2A of the Foreigners Act 1946. Now let us see what are the documents which the proceeding has exhibited before the learned tribunal. First, Lordship, kindly see voter list of 65, page 15. Page 15, this is the name of Nasser Ali Matabbor. Number 1, Nasser Ali Matabbor and Yatan Nessa are my grandparents.
That is okay. How did you introduce your documents as exhibits? Come to page 36. Page 36 and 40 of your petition.
Yes.
How was those exhibits introduced?
So this is evidence.
How, where is the exhibited documents?
Exhibited documents, madam, she has given a list of the
That is at page
exhibited
35.
documents. That is
at page 35.
35.
Without evidence, how can there be, without witness, without examination of witness, how can by philistia, what you call the exhibit be filed?
That is there, but thing is this, the learned tribunal has also stated the exhibit so and so. For a moment, let us go to tribunals.
But if you don't prove these documents, what is wrong in the opinion? You also think the same.
In the tribunal's finding, also kindly see page 51. Page 51, para 4, after submission of written statement, the proceeding as DW1 submitted evidence in shape and exhibited. So, exhibited some documents during the cross-examination, exhibit A, B, C, D, E, certified copies of voter list of 1965, 1970, 1997, 2010, 1989, exhibit A's, exhibit I, and exhibit J, certificates of concern Gaura. The proceeding stated in her evidence, as stated in WS, as claimed by the proceeding, that her grandfather, grandmother, mother, step grandmother, whether they are alive or dead, not mentioned, and brother Sadek
Sharma,
Ali.
we are really telling you this, the hearing officers of this type should be, you should review their performance. Mr. Das.
Prosecution schedule 1 after no. No. That's too low. Not at two, I would say.
Item 2 for motion.
Bad legal. My lord, in this case, my lord, the petitioner regularly could not appear before the tribunal, my lord. And as such, my lord, judgment was passed ex parte, my lord. It is page 27. Then, my lord, she filed one review application, and the review application with condonation of delay, and it is also rejected, my lord, on page 53, my lord. Hereafter, he approached before this honorable court, my lord. She has, my lord, one school certificate, my lord. Kindly, my lord, on humanitarian ground, my lord, because, my lord, it is a very vital one. This illiterate people, my lord, very valuable, my lord, right of citizenship, which also connected with other family members of the petitioner, my lord. Therefore, my lord, considering all aspects, my lord, and
If the, what you call the procedure does not turn out for
yes,
more than a year, what will it do?
yes, my lord. Here, my lord, apparently, my lord, she is negligent, my lord. But now, my lord, she has realized, my lord, and other family members are also connected with her, this kind of, my lord, citizenship right, my lord. And my lord, one aspect is there, my lord, in the, my lord, there is no, my lord, law as such, my lord, so far I know, my lord, time limit to challenge the order of the tribunal, my lord. It is a quasi-judicial judgment, my lord. Therefore, my lord,
Limited time. After 100 years also.
no, my lord, of course, but only, my lord, considering lordship balance of, my lord, the light, my lord, the right and liberty and connection with other family members.
Order 3, subrule 14, subrule for order what you call order 3, clause 14 of the furnace tribunal order. What do we do with that? You see, everything would have been okay. But this particular hospital which gave you a certificate is
My lord. My lord, would you expect, my lord, that one chance, my lord, only I have nothing to submit, my lord, because, my lord, there this kind of right, my lord, related to other family members also. Yeah.
I don't know. Plan. You also put BP series. 60% recovery, she made the earlier engaged advocate and told the case that the scope in process expiry order against her. BP. Yes, sir. 1, 2, 3, 4, 5, 8. BP BP and model hospital. Model reported. BP as well. Hospital sample, BP is not there. Bimala Prasad. BP is Bimala Prasad. I have BP is not. No, model high school report in date. The earlier engaged advocate and told that case disposed.
Main problem, my lord, my personal level, my lord, I have understood, my lord, they are illiterate, my lord, unconscious. Otherwise, my lord, in this kind of cases, my lord, the whole family will come together and, my lord.
Sixty percent recovery. Need to follow this. Yes, we can name it. Yes, civil hospital is there. BP hospital money ki? BP hospital money. Medical documents.
Medical documents. In the record, I am not an expert. Affidavit देना है तो बोला है one certificate page 25. Itu kita dengar. Okay.
Bogeshwari Phukanani Nagaon Civil Hospital. Bogeshwari Phukanani Nagaon. Eight. Bogeshwari Phukanani Civil Hospital. BP will be this. Maybe. BP. No? In a life. Huh? Lagi ke UPI asal naik ke bisa nih. Itu bisa. Mana itu sahaja? Ini malah ya itu ada itu. Saya gua hospital itu so. BP treatment in BP hospital Nagaon and hospital Gurupuri. Within. Mana mau puisi itu kita tahu. Jangan di sini lagi kalau jangan mau kiong ya. Sampai apa? Within. Bengal kiong ya. Maka nanti sini aku begini. Ini saja. Itu orang nanti uji dia kau dari minum dengan lu hai, no? Malah punya saya punya. Itu kau nak punya?
Nah,
Itu pun dia lah.
no, tapi dikit problem.
Itu semua. Bisa deh punya orang. Bisa. Kalau beja pun. Kau boleh. Lordships, I have find that Bogeshwari Phukanani Civil Hospital. Bogeshwari Phukanani Civil Hospital, Nagaon.
My lord. Yes, my lord. There's a reference to the fulfilling of the city and here the 10 minutes is some document must. Some document, my lord. Yes, ma'am. Yes, my lord. I also, my lord, instructed them, my lord, to provide some further document. Only, my lord, one aspect, mitigating aspect, my lord, as per my humble understanding is that, my lord. Of course, my lord, during trial she remained absent, but thereafter she filed one, my lord, application for review. And when, my lord, reviewer declined immediately, she has appeared before your lordship. So, basically, delay was not condoned, my lord. Yes, ma'am. And this, my lord, kind of, my lord, right and liberties are, my lord, they are connected with other family members.
You to your projected parents.
If your lordship is not primarily satisfied, my lord, another date may be given.
No. You see, the reason is page 22. Come to page 22. You have said nothing. Yeah.
WS.
Page 22 is shortest written statement we have seen.
Yes, my lord.
There is nothing to connect you to your projected parents.
But one certificate she has annexed page 20, my lord. School certificate.
School certificate. In Madrasa, pre-senior second year is which class?
Senior,
Madrasa-
pre-senior, second year.
In Madrasa education, pre-senior second year is which class?
Second year. Pre-senior it is one of the pre-senior it is like my lord pre-high school. That is, it is one of the, I think, below class 8, it may be. Senior madrasa equivalent to high school, higher secondary school. Electoral documents, my lord, page 15 onwards now. 65 NR, 1965 NRC, 1965 voter list, and 1970 voter list belongs to the father of Petitioner.
Is there any document here showing the date of your marriage? Or the document or any statement made anywhere about the year of your marriage?
Our evidence on page 42.
42.
42 only.
Just give us the date of marriage.
Only. In the WS only married that much written, but yeah.
Asking since you are the holder of this brief, you know more. That's why we are asking you about this.
Itu আমি married কারণ এটা married হয়েছে year year. One doctor was examined, my lord, page 47.
47.
My lord.
So we have seen that evidence.
Yes, sir.
That's why you got trapped. This is the cross-examination is the thing where you got trapped in this. It appears from that order. This is not a disease where a doctor will give you 3 months of bed rest.
My lord.
And thereafter, when he was caught, he said that I advise a bed rest is meant only for observation.
My lord.
There's no bed rest only for observation. Who will observe her in my home if I go and sleep for 3 months? Who will observe me?
Morning. Only my lord, negligence is there, my lord. Only my lord, other family members are innocent, my lord. She contested, and but this aspect of our right is, my lord, connected with other family members, my lord. Therefore, my lord, only for interest of justice, my lord, one chance, my lord, may be given to the expert order. I have annexed, my lord, two orders of this honorable court, my lord, also. Page 58, my lord, and page 62, my lord. 58, my lord, 60, page 60, my lord, relevant paragraph, my lord, last two one, my lord. Page 60, that being the position and taking an overall view for the matter, we are of the opinion that delay in filing the application for setting aside ex parte order may be condoned and the said application be heard and decide on merit. And another order I have annexed, my lord, from page,
You've seen that page 63.
yes, my lord.
You've seen both orders.
Of course, my lord, there is no much delay, but after all, my lord, allowed, my lord, only to decide the matter on merit, my lord. 63 relevant portion, my lord, says 64, as per my humble understanding, my lord. Other than the remorselessness being shown, we do not find any acceptable reason the petitioner for not appearing before the tribunal, and accordingly we do not find any infirmity in the order dated so-and-so of the tribunal. But as the petitioner was declared to be a foreigner without the appropriate materials being produced for a determination on merit, and also considering the remorselessness shown by the petitioner, we are of the view that the petitioner deserves another.
See, that's not the point. You took
No,
a
not
plea.
point.
In the tribunal, you took a plea. And the doctor's prescription says that your particular body part was to be removed. Now this, we adjourned this with an understanding that you produce the medical documents to show how the doctor give an advice. This is not an organ which visually one can say that, oh, your eyes there's a cataract, remove it. This organ is not like that. A doctor had advised removal of an organ.
And so much time is also not
That's
necessary.
okay, but you see, a doctor advises removal of an organ just to create a sympathy of the court in your favor that this is the advice. If the patient is serious. Now we wanted to know how the doctor could give an advice without to remove a body part without any medical documents, without any reports, without any ultrasonography. How could that be given? That's why we adjourned the matter. We are conscious of the fact that she is having a child of 10 years child with disabilities. We adjourned only for that.
Another date may be given. Right is, my lord, very serious. And my lord, precious right is one matter. But only very precious and very important right.
No,
of
right,
citizenship.
you take a plea, but that plea has to now, we will have to examine that plea first.
Yes, my lord.
With your written statement, with your nature of evidence.
And other, my lord, people are also involved, my lord, in this kind of judgment, my lord. Therefore, my lord,
You can at best adjourn it for a week. If you can get anything, you get it. Otherwise, don't find a case. Very few people are lucky not to have any disease. I am sitting here with a problem of my own. That's how we live with it.
Actually, my lord, these are, my lord,
Unless times I wear belt, I can't stand up. I have a slip disc, but that doesn't mean that.
ordinary, my lord,
You don't get the rights, you don't appear before the tribunal. That's not the way.
ordinary people has to, my lord, cross the bar of most intelligent people, my lord. This is the problem, my lord.
It is.
They don't know, my lord,
As a representative.
the consequences of all those things. my lord.
Petition for the non-affairs before the learned tribunal is not found. Not found satisfactory. So accordingly, on the prayer made by the counsel for the petitioner, the matter stands adjourned today. List, give a date after. After.
Obliged.
Item 3.
MH Rajbar on it. For the petitioner. Submits that he has no further instructions in the matter. That the brief and that his brief has been taken away by the learned counsel who had engaged by Miss. DJ Bora, who had engaged him. Next, we take notice of the fact that on 6/2/2026, when the matter was listed, there's no representation from the petitioner. The prayer made by learned counsel, for the petitioner, the matter stands adjourned today. The petitioner is put to notice that the petitioner remains unrepresented on the next date of listing, from adverse orders will follow. You just recorded your statement and adjourned it. If in the next date the petitioner is unrepresented, adverse orders will follow. List on. After 2 weeks, you did. List on.
9th of March.
Obliged.
Item 4.
May I please? My lordship, Mrs. Pori Bourbon in her legs in court number 90. This matter may be possible for the time being.
Item 5.
Page 26 is the opinion, my lord.
Here is your voter register of 1997.
Page 35, my lord. Move to the answer next to court. Page 36 is the original one. My lord, written history is very peculiar, my lord. Before that, my lord, her mother, his mother, yes, yes. Now, her mother was also, a case was registered against her. And she was, yes, yes. Paragraph 13, my lord. No, my lord, paragraph 13 is the written statement, very peculiar.
Case,
That also, before that, written statement is to be looked, my lord.
that's right.
Very peculiar written statement, nothing mentioned in the written
We
statement.
don't know, we just wanted to see that,
Paragraph page 13, my lord.
13.
Yes. Nothing mentioned about the, no.
Now we'll tell you what is the defect in your case. Come to page 36.
Yes, my lord.
Name of the village,
Khotorbori,
Khotorbori.
Khotorbori.
correct?
Yes, my lord.
Now, please come to page 66. That your opinion of your mother, page
Yes.
63,
Yes,
correct?
yes, my lord.
Third line, what is the name and address?
Thanagora,
Hmm?
Thanagora.
Yes.
Then she mentioned here in judgment that they are shifted. In their judgment, she mentioned in paragraph
Statement that's
paragraph
there.
2, paragraph 2 of their judgment.
No, you see.
Paragraph 2 of that judgment, my lord.
Two.
Paragraph 2. Paragraph 2 onwards. Like. Of village Goremari and later on shifted to Thanagora, the Marika of Sensu. This is ever in the license of Sensu. Nine? No,
Now, second thing in this is, you see, you are relying on that 1997 voter list. Your mother does not exhibit that voter list, although her name is there. There must be some reason.
yeah. Yes, it is not there. Twin of my writ petition, I mentioned.
But then there are two defects in, if you compare both the opinion. Number one, we showed you that page. What is that village?
Thanagora.
Hanagura. No, not Hanagura. It is Khatorbari.
Khotorbori.
It's not Hanagura.
Thanagora, shifted to Thanagora. Got married.
That page, we are more relying on this page 36.
36.
That is Khatorbari.
Khotorbori.
So there's no shifting. Khatwabari is there.
Yes.
You are picking up voters list and then making them your relatives.
But
Two addresses are different. Your mother can't live separately.
and if you also kindly permit me, page annexure 11 Melos brutal issue 19 I annex here later on.
Page.
If you have page 45. Those documents we could not produce at the time of Gauhati Tribunal. I
It's
mentioned
okay,
that.
but still it is Khatwabari.
Yes,
Your mother doesn't live in Khatwabari.
yes. Hajara Khatun, page 40. Khatwabari. Those documents also she relied in her case.
You see, we are comparing documents which we have for in this case, page 36. In this in the evidence of your DW1, in your written statement, that 1993 is not there.
Yes.
DW1.
Nothing mentioned here, nothing.
DW1 also does not exhibit that document.
No, my lord, no,
Then-
nothing.
Then,
Otherwise, nothing, my lord. Nothing, my lord.
because if both are,
If
you see, it can't be that the mother is having a different voter
My
list,
lord.
the son is having a.
they should have mentioned, specifically mentioned, but not nothing. my lord. In written list, is very peculiar. So, like, once asked me, can we given to remand back the matter? Will after he's a let the take a chance to produce all those relevant documents. Lordship, at least the conduct, I am not believing the lawyer. Written statement you kindly seen. Nothing mentioned, my lord.
You see, we can't help it.
Yes, my lord.
You will, when I say certain things, you will, after you go out, you will condemn me. You see, in the bar.
No, I am not taking such
Let
play,
me
my lord.
something. In the bar, one senior lawyer in the bar did a, what you call, lawyers upgradation skill program
My lord.
about a year back. And in the bar, I think hardly 40, 50 people were there.
Yeah.
Nobody was interested to upgrade their skill. About a month back, I had a program in the Lawyers Association Gauhati. Attendance for upgrading their skills in the trial court, CPC Evidence Act and CRPC. There were hardly 20 lawyers.
No, I also published a book. I am forwarded a book written by my junior, drafting and pleadings of the Fairness Tribunal.
But
They are back here in circulated. Thereafter, they are now, my lord.
I don't know. That's
I
why we
published a
don't-
book on that
That's why we
point.
don't blame anyone.
My lord. That is why I am not giving any blame. But just a chance can be given since
Yeah.
his mother has been declared as Indian. His father.
But this is your two cases were differently conducted, different documents are there.
Yes, my lord.
If mother is in the voters list of a particular village, why she will not disclose it?
Yes, my lord.
Because then mother becomes a voter in two what you call in two constituencies.
My lord.
So therefore, you
But,
calculative move. You
But
don't want to.
she disclosed about her children's. In here, he disclosed about her children. She disclosed about her children. That is mentioned in that judgment.
No, we understand, but you see, why will there will be two voters list? That's why you are very calculative. 1993 voters list is of a different village. 97 is of a different village, which one doesn't give. And the other one doesn't give the 1993 voters list. Why they will do that? Why pick and choose documents? Because they do not want to be exposed that they are voters in two constituencies.
Correct, my lord. Nothing, my lord. So, lordship, if one opportunity, because that record may be called for, my lord. For interest of justice, that record
No,
may be
you
called
have that
for.
record. You have filed it.
Now, the judgment is there. Other documents are also
No,
there.
other documents will not be considered.
Because voter list, I giving some voter list here.
regarding
Is it your case that the mother filed other voters list or did not prove it? That also goes against you.
some land document also exhibited, my lord.
Land document exhibited by whom?
Petitioner also exhibited one land documents, two land documents, my lord.
Petitioner.
Yes. Exhibit I and exhibit J, my lord.
Is the document at page?
9 and then, page, my lord. Page 58, my lord. Sorry. Sorry, my lord. Page 37 and 41, my lord. 37 is the sale deed. 38, my lord.
It's an 84 document.
Yes, 84 documents. And
One any document from
and patta is, my lord, 70. Page 42, my lord. It was November 1970. Selma Saman Ainuddin, his grandfather, my lord.
This page 41, who is the owner of this land?
Ainuddin, my lord. Serial number 7.
No, but who is he?
His grandfather.
Grandfather?
Yes, my lord. In my affidavit, I given the family tributes, my lord.
Where is that? Which page?
Affidavit number is, my lord.
Which page?
Paragraph 2, page, paragraph 2.
Paragraph 2.
Yes, paragraph 2, my lord.
Which page was your patta? One.
Patta 32, my lord. Patta nang 32, page 42. If lordship kindly the page 53, new document I submitted here.
Fail to understand. Why would someone shift from one village to another?
Not mentioned, my lord.
Now, if your grandfather has a land in Goraimari, why would you shift from there to another village?
Because
and from another village to another
other
village?
families are there. We are settled.
You don't
The
say
father settled. Not
Don't say
mentioned.
anything.
Not mentioned, my lord.
Hmm?
Not mentioned.
And-
Other here
And
other
your grandfather is alive, I believe?
no, no.
No.
Father also father also not alive.
You did not take steps to have your name mutated?
No, my you'll also can see new document I am placed here. Page 53. Yes, my lord. That particular line, my lord. Page 54 is the original, my lord. Also can see same tag number 283. Pattern number 32 is there. Same village, my lord. Then, my lord, page 57. 56 is for you, my lord. Our name has been muted in the CITA. Those documents were not produced before the tribunal. After death of Ainuddin, his father's name also recorded. Later on, they produced me a government copy. I could not bring it on record. Later on, my lord, they have furnished me a government copy, but I could not bring it on record, my lord. This is the original government copy, my lord.
It doesn't take us anywhere. No, we don't, we are not satisfied. You see, there's no continuity. This document, you are showing it to us. The pata number is 81. And dark number is 85. Page 57 does not have that dark number.
Yes, but
Now, in this document, the land holding is 5 bigha 11 lachas. And in this page 57, there is 14 bigha 1 katha and 15 lachas. How does it match? Dark number doesn't match, quantity of land doesn't match.
I don't know, well, maybe hence the number
No,
subsequently.
we don't know, maybe you don't get an order just for
But,
maybe.
so far as CITA is concerned, our name entered.
No.
CITA. In CITA, could be.
No, that's okay.
No.
If you are fighting a civil suit, will you concede that, okay, this doesn't match and this doesn't
No, it
match?
is.
Maybe it is happened and therefore, please pass a decree against me. Will you say that before the court?
No.
Then,
Otherwise, no, I have no case, my lord. I have no case otherwise. But if the laws will give one chance, then he will try.
okay, we'll examine. You can give a photocopy of this,
I-
because
I'll-
otherwise, if we keep it, we can lose it. We'll examine it and pass orders. Heard Mr. J. Ahmed, and counsel for the petitioner, and so and so for the respondents. Argument is concluded or what is reserved?
Hello,
We'll examine it. Mr. Sharma, while we are examining, we are also examining that mother's what do you call it? Opinion.
Yes, Lordship.
We append it,
I give the copy.
Otherwise, Lordship, in 2015, Lordship, mother's opinion has been passed, Lordship, but during
2025.
Oh, yes, Lordship. Then
Cases
otherwise, Lordship, he never disclosed before the tribunal that there is a proceeding pending against her mother, or nothing has
No,
been
that's-
disclosed in the.
Just examine
written
both the documents which are there.
Yes,
We
yes,
try to get a
Lordship.
link and then,
Yes.
that's why we have made CV.
Hello.
The disclosure is not there. You are right.
Yes, yes, Lordship.
We noted.
Item 6 with 7 for motion.
Madam will take a date for reply. We'll take a date for reply. I've received a study on interest. May I please, my lord? Yesterday we have received this.
Please button up your coat. Otherwise, we don't see you.
Sorry.
Yes.
Sorry, ma'am.
Lordship, in this matter, we have filed our affidavit yesterday, Your Lordship. Both the matters, Your Lordship.
And we are seeking some time for reply, madam.
Yeah, one takes some time for reply.
The affidavit copies are not tagged with Your Lordship.
We have seen that. Okay. We thought that no affidavit was filed.
Yesterday, it has been filed, Your Lordship.
Both sides are represented. The learned standing counsel for the revenue department submits that an affidavit in opposition by the state. All the respondents?
For the revenue department, the
For the revenue
impugn
department.
notification is
But
from
who's
the
from
revenue department. Your Lordship.
You're not filing affidavits?
No, Your Lordship, the impugn notification is issued by the revenue
No,
department.
we don't know, but you see, please come here
Yes, Your
to this cost title.
Lordship, we have filed it
Is
yesterday.
the chief secretary,
On behalf of
the commissioner secretary, you are representing everyone or? But
This will cover, Lordship. Joint secretary has filed it,
no, no.
but it is the stand of the
So
revenue department in the government.
Responsible one will take the stand of.
Yes, Lordship.
That's why we
Yeah.
wanted.
It will be a repetition if we file it by the
No,
secretary.
no, because we.
It will be the same thing. A very detailed affidavit we have filed
It's okay.
with all annexes.
No, no, that we want to keep the record straight.
Yes, Lordship.
Where is there we are recording.
Yes, Lordship.
But Mr.
David.
During the counsel for the petitioner, who submits that he has been served with a copy of affidavit in opposition filed by the state yesterday and seeks some time to examine and file affidavit in reply if so advised. Mr. D. Cycle, an advocate general for the state, assisted by Ms. N. Bordole, learned standing counsel for the revenue department, present. Next, the registry shall tag the affidavit filed by the revenue department on record. Next, the learned advocate general has submitted that the stand taken by the revenue department would also suffice for the respondent number one. Next paragraph. Matter stands adjourned today. List.
Maybe next week.
Lordship, if they want to file a rejoinder to our affidavit, let them do it. Otherwise, Lordship may fix the matter for final disposal after 15th of
No.
March.
Let the readings be complete because.
Yes,
you
because they may like to.
Now we'll be filing. Lordship, we must 2 weeks.
So then you'll have. some
Yes,
time
yes,
to go through it.
then a date may be fixed for final
That's right.
disposal.
Affidavit reply, if any, be filed within 2 weeks. would be. Within 6/3/2026.
Six.
Which time is given to the state to file. Counter if any new facts have come to light. Next, will be issue raised in this PIF. This is the matter for further consideration on 3rd week of March, CA date.
It will be 19th of March, Lordship.
That will be suffice.
19th?
It will be okay.
Okay.
It's okay.
They are agreeing, Lordship. 19th of March.
2026.
Highly obliged.
Hello.
We'll also take a short break.
Yes.
Time being item 4 for motion.
May please, your lordship.
Yes.
The order was passed in 2011, my lord. Tribunal order.
Yes, seen that.
Last of it, the lordship directed to take instruction whether where is the person now, it is in
Yes.
Annexes G, page 26 of my petition. It's the ex parte order, lordship.
Is he available? Is he available? This my opinion was of 2011, declared foreigner. He's in the country or he's not there.
Yes, Lordship. I'm not getting the instruction, Lordship. Within 2 days, Lordship, I shall get it, Lordship.
Next Monday then. You just make a note. So you're
Yes,
not,
yes.
making that in the order.
Lordship, Lord.
Much of.
But this, you say both sides are represented.
Huh?
Here made by Mr. G. Sharma, that standing also for the MP.
Legally do asilo.
This one, make it Monday.
Most side.
He তাক ডিটেনশনত থৈছিলে 2015 He আছে নে নাই সেইটো নাই Much of.
Item 8 for motion.
May appeal also, no, it is a contempt petition, my lord, against non-compliance of the judgment order of the single bench as well as the diligence of the court.
Which is the order? Which page?
My lord, in the WA number, page number 23, my lord,
23.
23. This is a losses order, my lord, judgment. The detailed judgment you have to dealt with. And last paragraph is very important. They went to Supreme Court also. There also the SLP was dismissed. Last paragraph, my lord, 36. This appeal dismissed the decision of the land single judge, right, so in the sense would apply purpio vigore in respect of the private respondent 1, 2, 3 in this appeal. So this was of my lord, this was passed in the month of June. Now 8 months passed. They have not complied. Then they went to Supreme Court. There also they got the dismissal order. SLD was not even, notice was not issued. Page 42. What is one? What is issue one?
But Mr. R.P. Sharma, Ranat Senior Counsel, assisted by
Miss Kedas.
Ms. A. Das, K. Das, Ranat, for the
Sabbir Siridas.
counsel for the petitioners. Next. By filing this contempt petition under section 12, the Contempt of Courts Act. The petitioners allege deliberate and willful violation and disobedience to the judgment and order dated 13/6/2025, passed by this court in WA 215 of 2024. It is posited that the said order passed by this court was unsuccessfully assailed before the Supreme Court of India it is also submitted that the order of this court, along with the representation dated 2/11/2025, was submitted to the respondent number 1. But the order has not been complied with. Next. Issue notice returnable on, give a date after.
Can you remind 21st of April?
21st April.
21st April?
21/4/2026. No, not 21, it'll be 22nd.
22nd, yes.
22nd April 2026. Petitioners can take step to the police for service of notice on the respondents. By speed post with DD. But the next part, the learned instructing counsel is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next paragraph. The pendency of this contempt petition shall not be a bar for the respondents to comply with the directions contained in the judgment and order dated 13/6/2025, passed in WA 215 of 2024. Yes.
Outline. Liquidado. Issued on the respondents.
Item 9 promotion.
Made, please, Your Lordship. Contempt petition, my lord, against the order, my lord, please may kindly see operative portion, my lord, page 72, annexure 6, page 69, my lord. Annexure 6, page 69 is the order, my lord. And operative portion, page 72, my lord. There are 12 and 13, my lord. May I read, my lord?
And Mr. N. Borat, and counsel to the petitioner. The petitioners and our petitioners filing this contempt petition under section 12 for the Contempt of Courts Act of 1971, that with Article 215 of the Constitution of India. Petitioners which willful and deliberate violation of non-compliance of the order dated 15/9/2025 passed by this court in WBC 4676 of 2024. They submitted that despite the presentation along with a copy of the order submitted to the respondents on 24/9/2025. Order is not been complied with. 24/9/25. So that is not been complied. Same issue notice. Make it same day. Steps within 2 days. Here doesn't belong to us. 21.
My lord, much.
Same day. It's a complaint.
Item 11 for motion.
May I please, Your Lordship? With sincere apology, Lordship. Lordship, with sincere apology, Lordship, I submit that there are some typographical mistake regarding name of the proceeding, Lordship. So I am praying, Lordship, I may be allowed to withdraw, Lordship, with liberty to file afresh. Because the same mistake occurred in many places, Lordship.
Name of the petitioner and therefore.
Not petitioner, Lordship, proceeding, Lordship,
Achha,
because the proceeding
Proceeding.
has expired, Lordship.
okay, proceeding.
Lordship.
Proceeding, and therefore, you please leave to withdraw this writ petition and to approach again. To stop. All the so-and-so appears for the respondents. The prayer is considered and allowed. The matters are dismissed on withdrawal with liberty as prayed for.
Lordship, I'm deeply obliged.
You, Mr. Abbas, you need a return of the Wakalatnama? No, not required.
No, Lordship, if you, Lordship, allow, then it will be because it's mistake on my part.
No, that's okay. Yes, sir. The court also permits the learned counsel for the petitioner to provide to withdraw the Wakalatnama. However, by providing a photocopy thereof to be retained on record.
Deeply obliged, Lordship. Obliged, Lord.
Item 12.
May I please, Your Lordship? In this case, today also my name has not been shown in the petitioner, though specific order is there. Yet, my lord, I have knowledge. That
Okay, we'll repeat that order.
Lordship, the case is pertaining to the order of 2019, my lord. And the delay part has been, my lord, explained in.
What is the explanation for that?
My lord, order is from page number 79 onwards, my lord. Yes, my lord. My lord, the linkage of the proceeding has been accepted by the learned tribunal, my lord, but the learned tribunal is of the opinion that the father's existence prior to 1966 is not there. While father's name is in the voter list of 1961, 70, as well as 79 with the grandparents' name. But all this shows that the case has been wrongly decided, my lord. Absolutely. My lord, at page number 81, my lord, that part is there, my lord. Page number 81, second last paragraph, my lord. Second last paragraph, line number 3 from the bottom, my lord. That all the above.
Where is the statement regarding your family tree?
My lord, in the WS, my lord.
No, wherever it is.
My lord, it is. Statement is not there, my lord. Family tree is given, my lord, in the very first.
Not there.
Family tree, I have annexed family tree, my lord. And in WS, my lord,
Where is your written statement?
the WS is that paragraph, page number, my lord, 35 onwards, my lord. There is also additional WS, my lord.
Where is the document 1960, 71 and those documents, where are they?
Lordship, that is from page number 43, my lord. 43, my lord, page number 1961 total list, my lord. Here, my lord, the grandmother's name has been wrongly mentioned, my lord. It is admitted Samirun Nessa. 1961 total list, my lord.
Here, please. Yes, Lordship. Yes, Doctor. Yes. Yes. Solmani. Yes. Yes, yes. Yes, Doctor. I have seen the document, Doctor.
Yes, that part is early. And my lord, I think my best document would be my lord 57, page number 57. 57 is at, no, that's, sorry, Lordship. Sorry, Lordship.
Village is same, Doctor. Yes, Doctor. Yes. Same. Solmani. Yes.
Did the records come, Lordship? Records may be confirmed. Lordship.
I think this repetition on Article 226 of the Constitution of India, the petitioner has said, page 78. Opinion dated 30/4/2019, passed by so and so in case number so and so, FT case number so and so. Thereby declaring the petitioner to be a foreigner of post 25 for 1971 stream. That's good. View of the inordinate delay in assailing the equal opinion, keeping the issue of misdemeanor open, comma, issue notice returnable in 4 weeks, extra copies within 2 days, call for the records to the following email address of the learned tribunal. Next question. Paid for bail is posed by the learned standing counsel for the FP matters. Considering the projection made in this question, 10 days time, take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Which place?
Gopalpura, my lord.
Gopalpura. And what is your explanation for the delay? Because
This is a poverty, my lord, ultimately, my lord.
where is that mentioned?
My lord, paragraph number 29, my lord, page number 30, my lord, 30.
You're keeping the issue of delay open.
Published.
Look, last time you say after the registry shall take note of the order dated 6/2026 and reflect the name of Mr. M.S. Tarukar as counsel for the petitioner while recently commenced.
Published.
Item 13 for motion.
May I please your lordship? Lordship, order is at page number 56. Order dated 30/4/2019.
Yes. Have you explained the delay?
Lordship, it is explained in written paragraph number 22, the petition. Lordship, for financial hardship. Record may be called for and
Financial hardship before engaging you or after engaging you?
still there.
No, but that explanation, it's which paragraph? Explanation.
Para 20.
Para 22, Lordship.
22. There is a good explanation. But then we'll have to dismiss your petition in limine even without going to anything else. You see, you have made a bold statement in paragraph 17. Or statement in bold. Now you say that the proceeding is barred under order 32. You claim that you are mentally you have a suffering mental disability. If the petitioner is suffering from mental disability, how could you take instructions from a mentally disabled person?
Lordship, at that time, not now. At that time.
That he is cured is not a statement here. So you are taking instructions from a person who is mentally disabled.
A certain time, Lordship. During past.
That's why I said you made a bold statement and then converted it that you made a statement in bold.
Who said it? Oh, good to see you.
But there's again a difficulty. Your citizenship was doubted as per documents, statements made here. That you were doubtful voter since 2005. So if you're a doubtful citizen from 2005, and there's a opinion operating against you, then you should have some urgency in selling that. That means from 2005, now you're in 26, for 21 years, you accepted that position. But your citizenship is doubtful.
সব কথার কথা খবর না লাগে রেফারেন্স কিন্তু ধীরে করে সামনে করে কথা কিভাবে ধ্যান দেন
Mr. Sikdar, we don't want to dismiss it in the hands of the young lawyers. We'll take it up day after protocol on Monday.
My lord.
It's good that you are giving opportunity, but.
My lord, what case is contested in a due manner, my lord.
We
So
understand,
there
but
are
delay
materials.
of 2019 to today, we are 7 years down the line.
Say, okay, my lord, day after tomorrow.
Monday.
My lord, Monday.
What says it presented on the prayer made by Mr. J. Sikdar, Counsel for the petition. Monday is 20.
Item 14.
Maybe, isn't it?
My please also, my lord, impugn order, my lord, at page 57, my lord. Yes, my lord. Order dated, my lord, 14/10/2025, my lord. Bongaigaon.
Bongaigaon. List of fools.
Obliged, my lord.
Item 15.
My lord, it is a very peculiar case, my lord. What happened? The petitioner was arrested on 2/11/2025 on the extent of NBW, my lord. Issued in a PRC case number 153/2022. Then, after inquiry, the petitioner came to learn that a case was decided against her in ex parte, my lord. That opinion is page 51, my lord. Ex parte opinion. 51. It is opinion dated 9/7/2017. Notice was not served to the petitioner. It is mentioned in the order also. Page 52, last para. The process server, so-and-so, reported that the officer in charge, Gwalpara, his first name Positi is not available in the village Koladanga. On next time, notice was issued to the Positi and directed to process server to hang the notice in conspiracy part in the bringer shop. Accordingly, notice was hanged by the process server, so-and-so. After execution of the hang notice, the original copy of the so-and-so. So this is a fact. I am not receiving any notice, my lord. Then the PSC case FIR has been lodged by the concerned police. Accordingly, not against me, but against 7 persons. In other 7 cases also, FIR is page annexure 1, my lord. Page 25. Process server is not. Process server report আছে. Process server report গুলা আছে নাকি? তাতে তো ফাইল আছে। এই অফিস দেখো বিল কোড। It is not there, my lord. The petitioner was also, my lord, earlier also, in one proceeding has been initiated against her. And that judgment is there also, page 80. That judgment ended there on 31/10/2023. Debtors also later on passed ex parte, my lord, declared as foreigners. In that case, she contested the case. However, all the cases were bundled for appellate by the authority, my lord, and after a long period, those cases were released, and thereafter matter was taken up, and notice was issued to the petitioner. Yes, I am custody in that. And criminal trial is going on, my lord. Yes, my lord. সেইটো কেছ ফাইল কৰি আছো সেইটো কেছ ফাইল কৰি আছো সেইটো suppose কৰি দিম। My lord, page 51, my lord. Later on, I appear contested the case, but later on notice issued, I am not received a notice. Another person received notice.
That record may also be confirmed.
Now I will going to challenge that order also. On 25, my lord, to 2/11/2025. Not against that case, earlier case I was arrested on. In case of that, page 51, my lord. GLP, FT case 8, GLP 571/2016. In that case, criminal case has been registered, I was arrested. 51, my lord. 51. In that case, reference was made to the FIR has been lost, we are arrested. Is this case? 2/11/2025. 5. Although I am available in Development, my lord. Matia. My lord, Gwalpara jail, my lord. It is, she was arrested in connection criminal case. Gwalpara jail.
This terms well so.
Hello, please.
Mars. Just, where is the reference to the criminal case?
It is Gwalpara, in session court.
Oh, no, not the, this, not the, this opinion.
No.
You are in Sessions case.
Sessions case.
Then the arrest is wrong. You make a malicious statement that the petitioner who has been arrested on 9/11, it was 9/11, no? 2/11/2025. In connection with Sessions case number
No,
150 of 2025.
PRC case number 153 of
Arising out
2020.
arising out of PRC number
153
1532
of
of 2022,
2022.
which is pending in the court of Sessions Judge from Gwalpara.
150. What to do? But it was also transferred to the session 50. 150. This is also transferred to the session court and number is 150, my lord. 2000. Order period.
Make that corrections. Sessions on.
So, where, my lord, therefore, in IA mentioned, state along 36, that is, I, after fixed to matter fixed after 2, because that is then I'm praying for leave of dishonorable to get impleted, and I said it's because in the repetition I was not completed. That is, we are affected.
We are not following you. What do you want to say?
I'm praying to upgrade the matter, to hear my matter after matter fixed after 2, as the lordship, because that IA is so important, it will be urgency there, my lord, that is why.
In which case?
36. One IA is there, my lord.
We'll take it up before rising.
Yes, my lord, that's highly obliged.
36.
Yes,
We'll take it up before rising. There are some old matters we have to do.
yes, my lord, that's highly obliged.
We'll resume after lunch. We will be 5 minutes late in resuming.
Time being item 1 for motion.
Yes, sir, Rocky. Rocky, here in this case, what is by 11/6/2018, Rocky, order is on the day the property concerned has filed the WS lordship, and during filing of the WS lordship, that document was enclosed. And after that lordship, on 1/11/2018, DW1 appeared, examined, cross-examined, and question put by the tribunal lordship.
Yes.
And after that, advocate for the proceeding lordship make a prayer to mark exhibits which are documents earlier placed by the tribunal. That's all, lordship. Lordship, here I have marked lordship. Lordship will kindly see 11/6/2018 and 1/11/2018 order, lordship. That will make clear, lordship.
That's it.
But the documents submitted by the procedure, I think lordship, all are copies of document, lordship. That is why lordship means some documents, lordship. Learned tribunal did not put his signature, lordship. 11/6/2018 order, lordship. After that, 1/11/2018.
No, you see, we'll examine other things later, but 11/6/18, the tribunal says that these are submitted as filisti, as exhibits. Correct?
Yes, Lord.
At this stage only, the tribunal could not have taken note of an exhibit without an evidence. But these are photocopies.
Yes, Lord.
Correct.
Tribunal did not mark it.
We understand. But then how was the documents introduced in evidence?
Lord. Oh, yes, sir.
In this affidavit, we'll send you the affidavit. Because the tribunal says that the cross-examination.
Yes.
Correct.
After cross-examination, Lord, after cross-examination, the advocate for the proceeding makes a prayer to mark exhibit on those documents, Lord. That was allowed by the.
That was allowed.
Yes. Later on, after proceeding discharge, lordship, that prayer was made, lordship, as per 1/11/2018 order.
It's still not satisfied. I'll show you why. We don't know. If you are satisfied, we have nothing to say. Come to these documents. It is at page 33 onwards, after the orange flag. If you are satisfied, we have nothing to say. That's it. After this orange flag, you'll find documents.
These are list of documents.
After that, you find documents.
Yes,
Now look at the first document.
1966.
No. We are interested in the signature of the tribunal.
Here is no signature.
No
Lordship.
signature. Now, next.
No signature.
Then no signature.
No signature. No.
Then,
Yes. No signature.
then you will find signature now. Red pen. It is not here. The next page, maybe I will from here. Can take out. The signature is red pen. Very flag.
Oh.
Correct.
Only in voter ID lordship
We
signature is
understand.
there.
The signature is there. Look on the date which it is compared with the original. Compared with the original 2013. And tribunal will sign in 2018.
Oh. Yes.
So where are the documents? Show us the documents where it is signed. Evidence of the evidence by Felicity is accepted.
Lordship 13 to 2 months.
We have better suggestion. The tribunal could have said the case of the petitioner is in the written statement. The allegations are in the application, and these are the exhibits. We reject all and dismissed. 31 paragraph.
In page 40, the compared with original, that is signed on 1/11/2018. Also, the immediately second page, page 41, that was also compared with original, that is 1/11/2018.
Perhaps his starting was wrongly some.
No, because this is a case of 2013. In 18, you will not sign in 13.
But in the second page, Lordship itself, there the sign was also in 1/11/2018, that compared by also 1/11/2018. So that's the immediate page. There's a mistake on the earlier page, Lordship, it seems. Because subsequent page is also the same, they is same, compared by same, Lordship. Only in this particular page, in page number 40.
That's okay, but you see, one you have to see exhibit A to J.
Lordship, that has not been signed.
Not been signed.
Because Lordship, I think Lordship, these are photocopies, Lordship. So
We don't know anything. He has accepted it.
yes, Lordship.
What happens if you accept if you accept the evidence, then what happens? Then signature is a mere formality. By judicial order, it's accepted.
In this document, there is no signature.
There's no signature. It must go back, the tribunal will have to sign it and send it to us. This can't be permitted.
Yes.
Only the limited You see, under what principles of law the tribunal has allowed exhibit by way of a feristy without leaving a statement in the evidence?
Yes.
What will we do? Have to dismiss the petition
Also.
on the ground that it is not exhibited in due process of law. Evidence on day one, what do you call it? Day two is the evidence. Day one, documents are filed. And day three, the documents are accepted in evidence. If the Home Department says you are comfortable with it, we'll approve it in our order. We'll say that these patterns are being followed, and therefore any illegality in the orders or marking of evidence will not be will be an acceptable format. You ask your secretary to file an affidavit.
Lordship. And on that ground, remand the matter, Lordship.
No, we'll not remand it. Now we'll ask the secretary to file an affidavit if they are comfortable with this affidavit. Is the manner in which this proceeding was done. They will not do, they will not give training to the presiding officers, and they will not do, this is certainly we will not accept it.
It is 2016. Okay. 2019 opinion, Lordship. So, Lordship. So, recently, Lordship.
Mr. N.U. Mahmood. Heard Mr. N.U. Mahmood, learned counsel for the petition. He sent the records. Also heard so-and-so for the respondents. Next one. Though the matter has been listed in the motion column, but as the read petition to assail the opinion dated (14 to 2019) was assailed by filing this writ petition on 25/2019. On receipt of records, the matter has been taken up for final disposal. Next part. While perusing the records of the tribunal, it is noticed that the written statement of the petitioner was filed on 11/6/2018. Which is accompanied by a separate FIRISTI, FIRISTI, wherein apart from referring to exhibit to certain documents as exhibit A, TO2, exhibit J, and other documents as annexure 1, Roman 2, and Roman 3, Roman 1, Roman 2, Roman 3. Was filed. So the documents appended to the said FIRISTI are photocopies. Thereafter, so it may be stated that the petitioner as DW1 had filed her evidence on affidavit on 2/7/2018, and in this said, no, you say wherein no document has been referred to as exhibits. So thereafter on 2/7/2018, no, not there. So not there. You say that on the same day, that is 2/7/2018, the petitioner has also filed the evidence on affidavit of one Sadiq SADEK Ali as DW2, and even along with this said evidence on affidavit, no document was marked as exhibit. Both the DW1 and DW2 were cross-examined. And asked questions by the learned tribunal on 1/11/2018. And on perusal of the same, no documents have been marked as exhibit. Next, the records reveal that on 11/6/2018, the learned tribunal had passed an order to the effect an order was passed to the following effect. The handwriting is very bad. Let us tell you and go write it down. It is in page 4 of the syllabus. Just take note, because handwriting is very bad. The proceeding is present along with the learned LD full stop, learned advocate on today and submit the written statement with some photocopies of documents in support of a case, which are mentioned in the FIRISTI as exhibit and annexures. Full stop. It is directed to submit the affidavit of the DWs together, i.e. at a time. Next para, fixing for 202-7-18 for affidavit of DWs. Thereafter, on 1/11/2018, the learned tribunal, by allowing petition number 1692/18, accepted the prayer of marking the documents as exhibits. On a perusal of the documents which are accompanying the arrestee, it is noticed that the said documents are photocopies, and out of this said documents, exhibit A, exhibit D, exhibit C, exhibit D, exhibit D, exhibit F, exhibit G, do not bear the signature of the learned member. Exhibit E contains the signature of the learned member dated 1/11/2018. However, the said document is a photocopy. Similarly, exhibit F, not F. Similarly, exhibit G, G-1, which is again a photocopy, bears the signature of the learned member on 1/11/2018. But the document is shown to be compared with the original by advocate, dated 1/11/13, 1/11/13. Exhibit G2 and unsigned documents will be G2 also, G-2, not signed, photocopy but not signed. The other three signed exhibits are exhibit H, exhibit I, and exhibit J, which are in original. Just there's nothing on record to show that except for exhibit G-1, G-2, no other document, no other original documents were examined. How the photocopy of the exhibit E came on record is also not recorded in the order sheet. The reasons why other exhibited documents were not signed or authenticated by the learned tribunal is also not recorded in the order sheet. As per the contents of the opinion, they give you an opinion. The the learned tribunal in paragraph 4 of the incident opinion has observed as follows. Page 51. Blue pencil mark. Yeah? Next one. Therefore, it privacy appears that the procedure followed by the learned tribunal is not in accordance with the established principles of legal practice by courts and tribunals. Stop. By accepting carrying of evidence by way of heresy, the objections to the exhibited documents appear to have been waived. Next paragraph. The non-following of the well-established procedures of trial court practice in the courts and tribunals on the original site, having not been found in accordance with law, and it is observed that the procedural practice has not yet been formulated by the state. The court is inclined to send the records to the Home and Political within bracket B bracket close department to examine the records and to file an affidavit if they approve of the manner in which the trial is being proceeded in the foreigners tribunals in the state of Assam. Stop. Next paragraph. We expect the state to file an affidavit within a period of 4 weeks from the date of the order after examining the records. Next paragraph. In the meanwhile, as the matter has been adjourned, or the court is inclined to grant bail to the petitioner, namely so and so.
Already on bail.
The purposes and hand over the tribunal's records to the next standing counsel to the Home and FT and Home FT and Border Matters, just to transmit the same to the departmental authority. Next list on, give a date after a month.
I am already on bail.
So we're not
All right.
After 4 weeks, question. Yes, Lord. Yes.
Upgraded item 42, fixed at 2 p.m.
I'm grateful, Lordship. I'm in item 42 on BC with your permission. Ladyship.
This matter comes up, my lord, pursuant to your Lordship's order of 29th January 2026.
Yes. Oh, this is contempt matter. Okay.
Yes.
Okay.
Where your Lordships have the last order, my lords.
Yes.
Your Lordships had issued notice, my lords.
Yes.
If I may just read it, my lords, also for the convenience of our ladyship, my lords, Justice Count. Paragraph 3 onwards, my lords. It is submitted that there was a positive direct.
Mr. Kohli would be prepared. Don't worry. You don't have to read it. Just tell us.
Yes. So, my lords, your Lordships have fixed it today for also for the consideration of the interim relief. Your Lordships recall, my lords.
Yes, yes.
More particularly, my lords, for Honorable Justice Count, my lords, just a summary. My lords, this appellants here, the appellants before the division bench, challenged the orders of discharging them from service, and the judgment of the single judge, dismissing the writ petition, upholding the discharge orders. So matters travel before the before the division bench of this court. Division bench headed by Justice, my Lord Justice Urana, passed a detailed judgment, holding that the petitioner here, my lord, who is Suranjita Hajarika, a transport officer, the district transport officer, that the order of discharge is punitive and stigmatic. Court has held that she had completed her period of probation, and further held that all the appellants are entitled to the benefit of Article 311(2), namely, my lord, the departmental proceedings have to be drawn up before they are discharged. Now, the court also held that most of the appellants had completed the period of probation, based on which the direction is passed at para 140, setting aside the judgment of the single judge. The single judge judgment is set aside. And then 141(1) says, all the appellants who had completed their period of probation stands reinstated in service. 2 says that all those probationers who may not have completed the period of probation, they are entitled, the directions issued by this court should be complied with within a period of 50 days. Now, 147, my lord said that in case there are any appellants, so court had not identified any appellants, in case there are any appellants who have not completed the period of probation, in that case, the state was given the liberty to simpliciter pass a discharge order. Right? So, para 141(7) in my submission are those who had not completed the 2-year period of probation. That's clear from the order. Now, the state, there were 47 appellants before the court, 45 have been discharged. Insofar as the petitioner here is concerned, no orders have been passed, nothing has been done, she has not been allowed to join. though my lord had said that we are staying this judgment for a period of 30 days. 30 days if you want to go further to the Supreme Court. My client is on caveat, renewed 3 caveats. Till now, no SLP filed by the state. No review, nothing is pending. So now, my lords, they have not acted as per the directions issued by the division bench of 28 June 2025. They are in contempt. So my respectful submission is that they must be allowed to join immediately. They means in this case only one petitioner is there. That's the transport service officer. And the consequential orders should be passed. But before that, just that finding of your lordships at para 138.6. It's a detailed judgment, my lord. I see there is no contradiction anywhere or any kind of doubt. First, my lords, please have the petitioner's discharge order at page 99. Page 99, your lordship says that. Paragraph 3.
Secretary, you have to bring us down.
I am ready, Lordship, to assist. I didn't want my learned friend to raise an argument against me that I interrupted him. So I'll wait whenever Lordship permits me.
No. He has showered some praises. We may get carried away with it. You'll have to bring us down.
Lordship, first I may point out, Lordship, on instructions, we are not challenging that SLP. Somebody else.
One second. Let me conclude.
I'll wait.
Let me conclude.
I'm in Lordship's hands, Ladyship's hands.
I will show, my lord, that state has no intent to comply with this. I will show it, my lord.
Lordship, we have issued an order in a case. It's a non-controversy. We have issued an order of discharge in compliance of Lordship's order, but I'll wait.
It's okay. Just
No,
I'm not very serious, man. Therefore, I bring in some lighter moment.
Well, I'm not showering praises on your lordship. I'm just referring to, my lord, a fact, my lord.
Just a moment.
Committee person. The high level committee passport. No, not insofar as the petitioner is concerned, my lord, because there was a batch of petitions, 47 appealants were before your lordships. My client's discharge order is at page 99. And your lordships have ruled this is stigmatic and punitive. Which means what, my lord? Article 311(2) protection. Please see, my lord, 99. The third discharge order. I'm referring to your lordship's judgment, my lord, paragraph 3, 60, subparagraph 3, running page 99. My lords, has it?
Yes.
Your ladyship has? The third discharge order, by notification dated 21/1/2019, is in respect of the appellant writ appeal 14 of 22 Suranjita Hazarika. In the said order, her initial temporary appointment as district transport officer is mentioned after referring to the successful completion of induction and training. However, it has been also mentioned she has been appointed and working as DTO. It is also mentioned that the sanction for prosecution was issued at the request of the SP Dibrugarh. However, while discharging her, she has been referred to as probationer. Now, please have, my lords, page 107. Para 78. My lord has it.
Yes.
I am reading, my lord, just last 4 lines of paragraph 78. Moreover, moreover, in the first and third form of discharge order, which has been extracted in the judgment of the learned single judge, the foundational facts were evident. It must be held that the appellants have been able to prove that the respective discharge orders were punitive. And then 123, my lords. The lordship, my lords, have held that this discharge order is punitive, it is stigmatic. Page 123, my lords. I am reading, my lords, third line. Out of the 3 discharge orders, my lords, has referred to in paragraph 5 of the impugned judgment and order, the impression of the court on a perusal of the first and third. Third is the petitioner before lordship. Discharge orders is that it conveys stigma against the concerned appellants to whom these discharge orders were issued. Then, the second discharge order, though appears to be innocuously awarded, contains a reference that the said officer is under suspension. If the appellants who have been discharged by such discharge orders apply subsequently for entering into service, any employer would ask these appellants to produce the suspension order. Then there is remote chance of any further window for these appellants. And then, my lords, your lordships finally holds, my lords, at 138.6 at para 138. First, my lords, para 111 at 130. Running page 130, my lords, paragraph 111. Therefore, even assuming that the appellants were probationer, my lords, take it for a fact that we didn't complete our probation period. We are probationers. Even then, your lordship said, yet when the discharge order is based on foundational facts and the materials available against them was not the motive to pass discharge orders against the appellants are found entitled to the protection envisaged under Article 311 of the Constitution. This is a finding of fact by your lordships, my lords, based on the law, that I am entitled to the protection under 311(2). Then, my lords, in this case, the government has not recorded the satisfaction in writing as to why it is not reasonably practicable to hold such inquiry. Clause B of second proviso to Article 311(2) is an exception and not the rule, and therefore the same must be scrupulously followed, which was not done in this case. Please mark, my lords, which is found to vitiate all the discharge orders. Now, my lords, come to 138, my lords. Para 138, page 149. So all I have to show, my lords, that your lordships have held that I am entitled to the protection under 311(2). Page 19 or 20, if any question just is completed what period of probation. Now, my lords, please have paragraph 138, subparagraph 6 at page 149. Running page 149, the ladies. 6. The learned single judge has failed to consider the relevant provisions of confirmation of a probationer as laid down in the respected service rules for the appellants because, except for the Assam Police Service, all other applicable service rules envisage, please mark, a probation period of 2 years, extendable as provided therein, and therefore, at the time the appellants were discharged from service, they had completed their normal tenure of probation. Therefore, the appropriate government will have to take a decision in terms of the applicable service rules as to which of the appellants have not completed the probation period. So Lordship said that the appellants had completed that normal tenure of probation, that was 2 years, when the discharge order was passed. In this case, my lords, the petitioner joined on 15/10/16, 2016. So 2 years completed on 15/10/2018. And the discharge order is 21st January 2019. So your lordships held at paragraph 138(6) that they had completed the normal tenure of probation. There was no extension. Your lordships have also held that they were treated like regular employees. We were given second increments. That finding your lordships wants to see, my lords, that finding of your lordships is
It's okay.
yes. Now, my lords, please straight away come, my lords, to paragraph 140 at page 152. My lords have. Accordingly, the appeal, the ladies of justice.
Right.
Accordingly,
Like this Essential Commodities Act, we also have to ration our time. That's it.
and accordingly, the appeal is partly allowed by setting aside the impugned judgment and order dated 18/3/2020, passed by the learned single judge in writ petition so and so. Resultantly, the appellants are found entitled to the following relief. Please mark, my lords, the discharge orders in respect of all the appellants herein, which have been impugned in the connected writ petitions, are set aside. However, this relief is subject to the following. Number 1, those appellants who have completed their initial probation period of 2 years, and by taking into consideration the maximum extendable probation period under the respective service rules, that is, the respective service rules, are liable to be reinstated within a period of 50 days from the date of the judgment and order. So I say I'm covered by 141(1).
My
So
learned
please
friend can also read 2.
Please, I'm reading. 2 follows 1, Mr. Kohli. I can't jump to 2. Now 2 says, for those appellants
I'm saving
whose
time.
period of probation has not been completed, by taking into consideration the initial probation period and the maximum extendable probation period under their respective service rules, herein before, the competent authorities are directed to pass such appropriate orders as may be deemed fit and appropriate, considering the finding rendered in the judgment and order, as well as by taking into account all the relevant factors as may be permissible in law. This exercise shall be done by the competent authorities of the respective department within a period of 50 days from the date of the judgment. So your lordship said, in case whose period of probation have not been completed, by taking into consideration the initial period of probation, 2 years, and the maximum extendable probation. So maximum extension, my lord, is not a matter of course. Extendable, the word used in the rule is extendable by a further period of 2 years, which means they have to extend it. None of the appellants, my lords, before 47 had any extension of probation period. Their probation period that completed way before the discharge order. So your lordship held at paragraph 138(6) that they have completed the period of probation of 2 years. Right, my lords? Even if I go by 2, I assume, my lords, that I have not completed, I fall in 2. What have your lordship said? That competent authorities are directed to pass such appropriate orders as may be deemed fit and appropriate, considering the finding rendered in this judgment. The finding is that the discharge orders are stigmatic, discharge orders are punitive, all the discharge orders are set aside. Appellants are entitled to the protection under Article 311(2). So assuming, my lords, I fall in 2 and not 1, what my friend is saying, then, my lords, the departmental proceedings have to be initiated. Now, my lords, please have 3. 3, your lordships recall, my lords, pertains to the Assam Police Service officers. where your lordships found, as a matter of fact, that these orders were all backdated. These orders did not exist, non-existent. So your lordships declared them as void ab initio. That does not concern us. Now, please come to 4. It is clarified that the judgment and order shall not come in the way of the competent authorities in the government to initiate departmental disciplinary proceedings against the appellants in such way and manner as they may be advised. However, the state respondent should make an endeavor to complete the departmental proceedings within an outer limit of 90 days on date of its initiation. So within 90 days, you start, and within 90 days, you conclude. Now, for the appellants who were not in service, from the date of discharge till the date of reinstatement, they will not be entitled to back wages. Your lordship says no wages since you did not work during this period. 6, it would be open to the competent authority in the government to keep the appellants without any posting till the departmental proceedings, if any, instituted against them, are brought to its logical conclusion. And alternatively, it would also be open to the competent authorities to post the appellants at such place from where they will not be able to influence the witnesses. So your lordship said, you may not give them a posting, or you give them a posting at a far-flung area so that they are not able to influence the proceedings. Now have 7. If there are any appellants, your lordships have not identified any. If there are any appellants whose probation period has not been completed, which means, my lords, who is below 2 years. Because the lordship says normal tenure is 2 years. Appellants have completed the 2 years period. If there are, your lordships have not identified any appellant. If there are any appellants whose probation period has not been completed, they would become entitled to be reinstated in service. However, in respect of those appellants, the competent authorities, they would not be, in respect of those appellants, the competent authorities in the government shall pass appropriate orders to withdraw the respective discharge order already passed and to substitute the said discharge order with simplicity the discharge order of not having been found them fit for confirmation, so that no stigma would be attached to them. Then 141, your lordships kept in abeyance for 30 days. Give them time. If you want to test it in the hierarchy of courts, you want to go to the Supreme Court, go. No, you didn't say that. The lordship said abeyance for 30 days. Then 142, the appellant shall have a certified copy of this order to the respondent to bring this judgment and order to the note. So, my client, served the copy of the order on 1st July 2025. That's at page 166. I placed it last time. And no order has been passed, my lords, insofar as my client, the petitioner in this contempt petition, is concerned. Right, my lords? Alongside this, my lords, your lordships in the last order had recorded that out of 47, 45 have been discharged. Please see, my lords, that discharge order in my additional affidavit which I have filed. At page 188, running page 188, my lord, additional affidavit. All cyclo-styled order.
Mr. Chaudhary, you are making these submissions for a particular reason?
Yes, my lord.
Yes.
My submission is this, my lord. I have stated, my lords, in the last proceedings also, that every day, my lords, they are in contempt. Your lordships directed, my lords, you carry out this exercise within a period of 50 days. That period expired on 8th August 2025. Today, as I address your lordships, 8 months have elapsed since your lordship's judgment of 28th June. Day after, it will be 8 months, my lords. Till date, my lords, they have done nothing insofar as the petitioner is concerned. She has not been allowed to join despite she asking, allow me to join. They have not initiated departmental proceedings. So my respectful submission is, my lords, please, my prayer, your lordships has at page 20, your lordship saw it last time. And since, my lords, the state has been noticed now, your lordships, I will beseech your lordships, my lords, to grant me prayer B. Prayer 3. Page 20. Prayer 3. Pass ex parte ad interim orders directing the respondents to ensure immediate and strict compliance of the judgment and order dated 28th June 2025, passed by the division bench, and forthwith direct the respondents to contemners to permit the petitioner to join her service and release her salaries and other product which is payable.
Ask Mr. Kohli to respond.
And my lords, I will, at the end, I will point out, my lords, they have no intent to comply with this judgment. I will show that, my lords, there is a decision taken not to say that everyone falls under 141(7). Issue discharge orders to all. I'll place them. Let my friend first explain.
No, you make that statement because otherwise you will know what is to be done.
Yes. That's why, my lords, I was pointing out that additional affidavit of lordships have, my lords, page 188. And that is the state's answer. Though in this case, my lords, they have not issued me any order. They have not communicated to me any order. Your lordships have 188, my lords? Yes. Whereas, lordship just have, it makes interesting reading, my lords.
Yes.
188.
Yes.
21st July 2025. This is, my lords, Qua 45 who have been discharged. Whereas in compliance of the directions at paragraph 141(2), that's what my learned friend wanted me to read, my lords, read with para 141(7), passed by the Honorable Gauhati High Court dated 28th June 2025 in writ appeal number so-and-so and other linked cases, the Governor of Assam is pleased to withdraw the government order discharging Sri Mun Majumdar from Assam Civil Service via notification number dated so-and-so. And whereas, please mark, my lords, as directed by the Honorable Gauhati High Court, the case of Mun Majumdar, who was on probation in Assam Civil Service at the time of discharge, is considered, and upon consideration, she is not found fit for confirmation as being a member of the Assam Civil Service. I pause here, sir, my lords. Where did your lordships ask them to consider, my lords? And this is also ex parte. And, my lords, now therefore, the Governor of Assam, in exercise of powers conferred under Rule 20C, the same rule, my lords, is pleased to discharge Srimati Mun Majumdar, ACS from service with effect from 2/1/19. That is the date of discharge given by notification number so-and-so. Please mark, which stands substituted as directed by the Honorable Gauhati High Court. I pause here again for a moment. Your lordships held that this 2/1/19 discharge order is stigmatic and punitive. And they are again giving reference to that order, my lords. And now please see, my lords, the single judge bench judgment, a detailed order at 189. All these discharge orders have been stayed by the single judge, stating, my lord, that your lordship's judgment is clear, categorical, and emphatic. 189, my lords. A detailed interim order, my lords, records all your lordship's findings and contentions urged before your lordships. And straight away come, my lords, to page 201, para 13. So this is Justice Soumitra Saikia's. They can't do this, my lords. You have a problem, you challenge the judgment. Your lordships have para 13?
Yes.
At page 201. Having carefully perused the judgment and order dated 28th June 2025 of the division bench, it is seen that there is a specific finding by the court on the materials available before the division bench that the discharge order which was issued to the appellant, including that issued to the present writ petitioner, was found to be punitive and stigmatic. As such, the division bench did not consider such discharge orders to be discharge simpliciter. There is a specific finding by the division bench that the coordinate bench in the judgment under appeal has arrived at the conclusion that the probationers had secured employment due to a colossal fraud. The division bench found that such conclusion by the coordinate bench on the facts and discarding of misconduct as a pre-recruitment phenomenon is found to be contrary to the requirement of Article 311(2) of the Constitution of India and therefore held to be unsustainable. The further finding of the division bench is that the competent authority of the state never passed any order envisaged under Clause B to second proviso to Article 311(2) of the Constitution of India, and it was not reasonably practical to hold any inquiry, and therefore such actions were also found to be contrary to law. The division bench came to a finding that the coordinate bench had failed to take into consideration that the termination of the appellants, though projected to be probationers, in substance represents a penalty imposed on the appellants, and or punitive action was taken against them contrary to the law laid down by in Motiram Deka, so and so. The division bench concluded that Article 311 of the Constitution of India makes no distinction between a permanent and a temporary post, and therefore the conclusion of the coordinate bench was found to be contrary to the ratio laid down by the judgment of the apex court. The division bench concluded that the materials which are available and relied upon to pass the initial discharge orders were considered to be the motive to discharge the appellants from service and were not foundation for discharge of the appellants. It was held to the division bench. By the division bench, the judgment of the coordinate bench was found to be based on foundational facts emanating from the report of the Dibrugarh police and was therefore held to be not sustainable. Ultimately, the division bench partly allowed the writ appeals, however, interfered with the judgment and order of 18.3 and other connected. All the discharge orders in respect of the appellants therein, including that of the present petitioner, were set aside. The further directions extracted herein above of the division bench reveals that the appellants who had completed their initial period of probation of 2 years and were taken into consideration the maximum extendable period was liable to be reinstated within a period of 50 days from the date of judgment and order. Coming to the facts of the present case, then it comes to the facts and Malas Para 17. From the materials available before this court, your lordship has that, Malad? Running page 203. No, Malad, please see para 17, Malad. From the materials available before this court, Malad, this is a finding at the prima facie stage on the first day. Detailed judge order of the single judge. From the materials available before this court, it appears to this court prima facie that this direction of the court appears to have not been followed by the respondents. The petitioner, after an initial discharge order was interfered with, was set aside by the High Court. She was not reinstated in service as directed by the within the period prescribed with under the direction issued under para 141. Accordingly, this court will require consideration. Please see Malad para 22. Till the next date fixed, the impugned order dated shall not be given effect to. So, the court state the discharge order. Now, insofar as the petitioner is concerned, there is no such order. Till date, Malad, she says, not been communicated. We don't know. They have not taken any action. And their intent, my lords, is that everyone falls in 141.7 and issue discharge orders to all. And I'll place that, my lords. Just have, my lords. There is, my lords, after your lordship's judgment on 20th June, a committee is set up by the state of Assam. And the committee decides in its minutes that discharge everyone and the judgment, there are some errors in the judgment, apply for review. Till date, my lords, your lordships have not give him also important. Till date, my lords, all this should have been disclosed, my lords. Please see, my lords, 30th June 2025. It's a committee, my lords, of five members, esteemed members, my lords. And please see, my lords, I'll just place it. Please see what the committee holds.
Some long hands gave you this. Some long hands gave you this.
Today is the date of information, my lords. You can't hide. So please see, my lords.
Lordship, I'm very grateful for that observation.
During the deliberations, your lordship, during the deliberation,
my lordship,
it has come to light after proper examination of all the 5 service rules.
But, just a moment. But Mr. Kohli, I forget the citation. I'm a bit forgetful. 76 Supreme Court, the citation, I won't have it readily available. It says that even if the documents are got by unscrupulous means, it's still a document.
Not
that's okay. They can also be taken by scrupulous means, Lordship. RTI has become a great enabler.
No, not that, but that judgment I forgot.
Yes.
I'll tell you the exact citation, Lordship, in a minute. But once my learned friend comes, I don't think it's such a long matter, but I'll wait.
Not unscrupulous, my lords. Once Justice Fali Nariman had handed over. So the court asked, he says, my lords, a little birdie came and dropped it in my balcony today when I was going for my morning walk.
Also, there was the other one, Lordship, which goes back to the good old days, which was just recently quoted in one of the Delhi High Court judgments, that the republic without a pub is only a relic. I mean, this was the humor of the 50s and the 60s, Lordship.
Without a pub.
Yes, so that was, in fact, I was in Delhi High Court, Lordship, on a light note. Actually, the learned judge said that 1 minute, what was that quote? And then he quoted it. And then we were in court to say, yes, Lordship, it's a famous quote. It's attributed, of course. We still don't know for sure if it was a fact. And a republic without a pub is only a relic.
No.
Good old humor.
No, let's just have this quickly, minutes. Your Lordship will see minutes of the committee meeting.
You know, I just remembered when you said that observations. In fact, I was traveling somewhere, obviously with a jacket, wearing a jacket. A gentleman of repute comes and tells me, jacket at this time of the year, either a lunatic or a judge would wear.
Your Lordship would have said, I am both.
Comment to re-comment. Because, I could now be personally hauled up for contempt.
I'm just placing this, just see the committee was constituted at the top heading, minutes of the committee meeting on the Honorable Gauhati High Court judgment and order of 20th June. So after your Lordship judgment, a committee is set up. Then deliberations take place, if your Lordship see, during the deliberations, it has come to light after proper examination of all the 5 service rules in question, more particularly the provisions therein regarding probation and confirmation. In each of the service rules, there is a mandatory requirement of appearing in departmental examination after completion of probation period in order to become eligible for confirmation in service and become a member of the service. My lords, this is incorrect. In our service rules, transport service rules, unless it is prescribed, and there is no such prescribed, my lords, requirement of a departmental examination. Only if the committee would have given us a hearing also. Committee also proceeds ex parte. Now see, my lords, this aspect of requirement of appearing in departmental examination and successfully clearing the same was never taken into consideration during the adjudication of the writ proceeding and writ appellate jurisdiction. So, my lords, it says it was not, this departmental examination was not taken into consideration. In view of the above, it is abundantly clear that none of the incumbents, petitioners, writ appellants had appeared and or cleared the written examination, which is one of the prerequisite and mandatory conditions for the purpose of securing consent. No, they want a route. So they are saying that now there's a mandatory requirement of departmental examination. There's no such prescribed departmental examination. And the Lordship said 2 years is the period of probation, extendable by a further period of 2 years. Furthermore, after examination of the service rules relating to probation and confirmation in so and so, Lordship will see, the period of probation is well specified as 2 + 2 equal to 4 years. But this is also incorrect. Period of probation is 2 years, extendable by a further period of 2 years. It can be extended. Extendable. It is not 2 + 2. Now, please see, while in Assam Police Service Rule, the probation period is specified as 2 years, which is extendable without any upper limit. Thus, if we consider, now the committee goes into your Lordship's judgment, directions, passed in paragraph 141(7) of the judgment. That is, the Lordship said, if any of the appellants have, if there are any appellants who have not completed the period of probation, the Lordship didn't identify any. And as per the findings, it would be below 2 years. Now, please see, it quotes that paragraph. And next page, it is abundantly clear that none of the appellants, please mark, completed the probationary period as permissible with up to the maximum limit as specified in the. This is, my lords, contrary to your finding at paragraph 138(6), where the Lordship said had completed the period of probation of 2 years. This is the problem, my lords. You're sitting in appeal over the division bench judgment. And read further, my lords. Apart from the other important facts, what transpires during our deliberations is that none of the appellants have completed the prescribed probation period as mentioned. I pause here. This is in the teeth of your Lordship's finding at paragraph 138(6) at page 149. Your Lordships have held all the appellants have completed. 2. This wrong facts should not have been recorded, Millets. Now, 2, none of the appellants have ever cleared in any departmental examination to secure confirmation, which is also a mandatory requirement under the respective service rule. In view of the above, now please mark, the best course of action in our collective opinion is, number 1, to issue the order as mentioned in para 141(7) in respect of all the candidates. So, 141(1) to 141(6) has been thrown into the drain. They are going by 141(7). None of you have completed, out you go. Next, after issuance of the orders as mentioned in point
Lordship,
one.
this is short point is only whether an order has been issued or not. And we have issued the order. I'm going to save a lot of time.
1 second.
No, but I'm
Now
actually
two, my lord.
it's not a
After
review.
issuance of the orders as mentioned
Or a
in
writ
point
petition.
one, a review application may be preferred in the Gauhati High Court on the following ground, my lord. No review, my lord, has been filed. The aspect of
Lordship, that is incorrect. Just
my
to
lord, the
correct.
grounds have been specified. Right, my lord? So, my lord, this shows, and my friend was also, my lord, part of this deliberations and the committee. The lordships will see, my lord. It's a high-powered committee. My lords, the issue is this today. Here is a state, my lords. After your lordship's judgment, sits down in a committee of 5 or 4, 5 or 4? 5. Goes through your lordship's judgment and says issue orders under 140(1)(7) to all. I don't know how, my lords, my client till date has not received the order, or whether it is paper compliance. Even if that order is passed, my lords, my respectful submission is that order will be in the teeth of your lordship's judgment of 20 June 2025. It is ex facie contemptuous. It is deliberate breach and disobedience of the order. And now, my lords, after this committee's decision, well, what will the contemners do? It's binding on them. The chief secretary, the commissioner of secretary, lordships have not issued notice to the chief secretary. Yes. So my respectful submission is, my lords, every day of contempt, my lords, disobedience is a direct affront to the majesty of this court. My lords, I'm praying, my lords, that my prayer number 2, my lords, be granted, my lords, and she be allowed to join the service. I'm grateful.
May I assess, Lordship? So, Lordship, honestly speaking, this is not a review or an assessment of the judgment. The short point in this contempt is only whether an order has been issued or not. My learned friend has already read you the directions in para 140. He has relied on para 141(1). I have respectfully pointed out in between, and he has read it, para 141(2) and 7. So the only question is an order passed as per the fact whether that the person concerned before this court was a probationer or not. So please note 5 arguments one by one. First, Lordship may note that Lordship's judgment is stayed by an order of the Supreme Court on 10th of November 2025. The state hasn't challenged that. This has been challenged by some of the people who are impacted by this judgment, which are the those who are part of the same batch. Now, Lordship, that order is there. My sister is in court. She's going to share on it. The contempt petition has been filed on 28th of January. Respectfully, Lordship, I think this should have been brought to Lordship's notice at the threshold. But I'm going to, in any case, come to the merits also. Supreme Court stayed it while order dated 10th of November 2025. And I'm sure my learned friend is keeping himself abreast with every issue now that he's relying on so many communications and deliberations. This order wouldn't have missed his consideration. And they filed this on the 28th of January. So therefore, Lordship, one question that arises that, if an order is stayed and a petition is filed subsequently to
Not in our case. Oh, yes. It's in that writ appeals. Yes.
So there's the same order, Lordship. They relied upon it.
My writ appeal is 14 or 22, my lord. That judgment is not, that judgment where writ appeal 22 is not stayed. And I'm saying it with a sense of responsibility.
Lordship, whatever he may say, he may have chosen not to challenge it, but there is a stay on the judgment.
If the judgment is stayed, it will be for everyone.
Of course, Lordship. That is the basic law that I've learned.
In that writ appeal, and not at the instance of the state.
No, whatever be, but if the judgment is stayed, whoever gets a stay, but the issue is that whether the judgment will survive for compliance.
The issue is this. There were, your lordships, of 47 appealants. My client's appeal was writ appeal number 14 or 22.
It's a fully complete.
Yes.
So, Lordship, I think Lordship I don't need to even argue because it has flowed from the bench only, and I'm grateful for that. That if an order is stayed or a judgment is stayed, Can somebody today stand up and creatively or innovatively or very democratically argue that I am not the one who had gone up to the Supreme Court? It's a judgment. The judgment is applicable to everyone who was an appellant in the proceedings before Lordship. That's point one. So therefore, Lordship, respectfully, in fairness, this should have been placed as the very first thing for your consideration, for Lordship and Ladyship's consideration, at the threshold before making elaborate arguments that are more in the nature of a review or an assessment. Now let's come to the second point, Lordship. Is an order issued or not issued? My learned sister in the court will give. Lordship may mark the dates. The person who was approached the court was appointed on the 15th of October 2016 on probation. The discharge
You're
was
speaking of,
Lordship?
you're speaking for which the name of the person?
Yes, Suranjita Hazarika only.
Okay, okay.
Who was Lordship in the instant petition alleged
Yes,
contempt.
Yes.
So Lordship may just mark the date, which is also borne by the own discharge order, which is part of the pleadings. 15th of October 2016 is the date of appointment. And Lordship, as is brought by my learned friend only in the contempt petition, the date of discharge is 21st of January 2019, which is less than 3 years. Now, Lordship may please come to Lordship's judgment only at page 95, where the Transport Department rules are there. Is Lordship at page 95?
Yes. Just a moment.
And Lordship may note the Assam Transport Service because the...
Just a moment.
Lordship, Ladyship may come to page 95 of the paper book.
Yes, please proceed.
And may please see 21, Rule 21, probation and confirmation. May I read? Subject to availability of permanent vacancy in the respective cadre, a member shall be placed according to his seniority on probation against permanent vacancy for a period of 2 years before he is confirmed against the permanent vacancy. And ahead is important, provided that the period of probation may, for good and sufficient reasons, be extended by the appointing authority for any specified period not exceeding a period of 2 years. Lordship may note that the rules provide a 2 plus 2, 2 years probation, extendable by another 2 years. Now, in having read the rules, Lordship may once again read Lordship's own direction at page 152, because the state has complied. Would Lordship see the directions at page 152, and if Ladyship can also have para 140? This is subject to the following. This is subject to this. Now, Lordship, there is a judgment as Lordships have penned. That judgment has a set of directions. Those directions are qualified in para 141. Please come to the last sentence of para 141, where it says, however, this relief, which is the relief of the judgment preceding paragraphs, is subject to. So it's not a blanket relief. It is subject to the following. Now we may read, Lordship, only 3 paras, 1, 2, and 7. 1 is what my learned friend in the petition has specifically relied on. So in fairness, we should start with that. Those appellants who have completed their initial probation period of 2 years and by, please mark, by taking into consideration the maximum extendable probation period under their respective service rules, i.e. so and so, are liable to be reinstated within 50 days. Then what does Lordship say in 2? For those appellants whose probation period have not been completed by taking into consideration the initial probation period and the maximum extendable probational period under the irrespective service rules referred here and above, the competent authorities are directed to pass appropriate orders as may be deemed fit and appropriate, considering the finding rendered in this judgment an order as well as by taking into account all the relevant factors as may be permissible in law. This exercise, as lordships have laid, shall be done by the competent authorities of the respective departments within a period of 50 days from the date of the judgment. And most important, lordship may come to page 154, and if lordship ladyship would see 7, Roman 7. If there are any appellants whose probation period has not been completed, now please mark, lordship, I said that she was appointed in October 2016. She was discharged in January 19. It is less than the maximum extendable period of 4 years. She is in fact less than 3 years also. They would not become entitled to be reinstated in service. This is lordship's finding. However, in respect of those appellants, the competent authorities in the government shall pass appropriate orders to withdraw their respective discharge orders already passed. Pause. You have done so. Please withdraw. She is one of them. And to substitute such discharge orders with simpliciter discharge, meaning even if the order is stigmatic, the government is directed by lordship's judgment to substitute the said discharge orders with a simpliciter discharge order of not having found them fit for confirmation so that no stigma is attached to them. Now, lordship, the next question will come. Have we issued discharge orders or not? My learned sister in the court is carrying the discharge orders. So, lordship, there was first a discharge order, then there was a recognition that a 50-day period was there. So, a corrigendum was there. Now, if lordship may see that. And there's also all without prejudice to the first argument being that the judgment stands stayed by the Honorable Supreme Court. So, would lordship like to see those discharge orders for the petitioner before lordship? Has lordship, ladyship got that? May I read lordship? 11th of July. Whereas in compliance of the directions at para 140 read with para 147, I just read it 17, passed by the Honorable High Court, Honorable Court dated so and so in so and so, and other linked cases, the Governor of Assam is pleased to withdraw the government order discharging Srimati Suranjita Hazarika from the Assam Transport Service, Vide order so and so dated 21/1/19. So lordship in 7 said withdraw the old order, come up with a simpliciter. Now I read, and whereas, as directed by the Honorable Gauhati High Court, the case of Srimati Suranjita Hazarika, who was on probation in Assam Transport Service at the time of discharge, Vide order dated so and so 21/1/19 is
served this to the she's not even marked, she's not even named. Just see the next page.
lordship. Let me 1 minute. Lordship.
Paper compliance, man.
Lordship, me 1 minute. Well, what is paper compliance? This is an order of the government. Now, lordship, let me ask for a second. If my learned friend, let me put it in, doesn't take the order, doesn't do anything.
Something very serious, man.
Let me also say, the government doesn't send whatever. Can that be contempt? The question here is only one thing. Was there a compliance and was there an order? I'm saying it and I'm showing before lordship that yes, there is an order in compliance without prejudice to the fact that the judgment stands stayed 2 months prior to my learned friend filing this petition. That's the crux of the case, lordship. And I would respectfully say there is no ground for contempt because there is compliance. Now I'm in your hands, lordship. And let me say a last sentence, lordship. If my learned friend is agitated with any aspect under the sun about the judgment, its compliance, delivery, non-delivery, that will not lie in a writ. If that will not lie in a contempt jurisdiction.
Just a moment.
Lordship, I'm sorry. I'll wait.
One 31, 23. And not asking. I have to send the card for the why send for it in after 131. Last moment takes next one of the direction of auto brand.
Just one thing, Lordship, just to let Lordship know a statement of fact. This is not just one SLP. 4 more matters have been filed. They've all been tagged with the order of November, which has stayed the judgment.
11th March is the next date.
The next date is 11th of March, Lordship. Just as a matter of knowing, sharing the dates of the SLP of the Supreme Court.
Yes. Yes.
So, Lordship, just to reiterate, my first submission for consideration of Lordship and Ladyship is that the relied upon judgment stands stayed by the Honorable Supreme Court, widely order dated 10th of November 2025. Subsequently, additional SLPs have been filed by the discharged officers who are the beneficiaries of Lordship's judgment. The next date of hearing is 11th of March. Now, number 2, the directions in para 140 apply to everybody, not to A, B, C. It is applicable to all the writ appellants. And the fact that the judgment is stayed, that would be applicable to everyone. That's my second submission. Without prejudice to these 2 submissions, the state, I have placed and shown Lordship that the rules provide for a 2 + 2 years, which is recorded in Lordship's judgment. 4, in compliance of the directions in para 141 Roman 7, relying on the rules quoted in the judgment, which is of the Transport Department, Rule 21, the state has issued that discharge order in July and a corrigendum subsequently. And finally, without prejudice for a second time, if my learned friend is agitated with any other aspect, this is not the forum or proceeding in which it can be agitated. He can take whatever remedy under law that is prescribed for his client. This is the crux of my argument, Lordship. I am grateful for that.
Recruiting number? By registration देगा.
Yes.
Yes. I had on the last occasion, if a lordships have the 29th January 2025 order, when your 26th order, when your lordships issued notice, I had expressed apprehension. In case your lordships do not protect me with an interim order, they are going to, my lords, show paper compliance and pass an order of discharge. Now, my lords, please have the order of discharge which my friend has handed over. My lord, this is a petitioner who is in correspondence with the department. It is not that someone has gone missing. See, her address is known. She writes a letter on 1st January 2025, 1st July, that you please comply with the directions of the division bench of the High Court. That order, letter your lordships have seen, my lords, at page 166. That's on 1st July 2025, 166, my lords. In terms of your lordship's direction, the certified copy was given by the petitioner. She went to the department, gave them a certified copy with a copy of the letter to ensure compliance at page 166. No, my lord, this is very, where does the citizen go? And look, my lord, the orders which have been handed over to your lordship. I am on affidavit, my lords, that on the day I filed my petition and even till today, I have not been aware of any such orders passed by the department. There is no order. And see this order, my lords, 20, the second page, my lords. Second page, serial number 20, Srimati, blank. Is this the way you pass a discharge order? Who are you addressing these discharge orders to? The person who is impacted by the discharge order, you don't even name her. Look at the casual manner, my lords.
Lordship, I will not permit these comments against the state.
One second, I'm making my submissions on the record. I don't need your permission.
No, Lordship,
I'm sorry. I don't need your permission.
I am sorry. This is not for the
This
gathering.
interference, my lord.
I'm
Let
saying
me
it
complete
clearly.
then, my lord.
This is no, Lordship. This is not done.
This is not done, my lord. My friend.
Comments against the state government in an election year.
My lord, I'm sorry to say this.
I'm saying it absolutely
Mr.
open.
Kohli, Mr. Kohli, this is the document produced by you.
Yes, of course,
He has
Lordship.
he has a liberty to.
Right,
clear it
Lordship. But Lordship, he may make whatever he wants on merits.
My lord, I have nothing to say, my lord. This is what
because
my
Lordship,
friend
this
is.
is not done.
You see, no, Mr. Kohli, then perhaps we two are in a different page. You see, the reason
I
is.
bow to it. Lordship feels so. That is the difference.
The reason is that we also asked the first question, how did you serve it?
Of course, Lordship, but then therefore, Lordship, respectfully, with no disrespect to the bench, not at all. My humble thing is that Lordship has to consider it in the scope of two questions only.
We'll examine it.
Of course, Lordship, that's all. I made my arguments on that. But I would just say my learned friend on law can say what he wants, but we can leave the adjectives out, Lordship, in this period. That's all.
I'm sorry, I don't need your permission to address.
I'm not even saying my permission is needed.
Yes, I'm entitled to argue, my lord, on the matter of fact. If my friend is saying,
please proceed.
Yes, my lord. So, my lord, paragraph 4, your lordships recorded, my lord, my apprehension that accordingly it is submitted that the petitioner apprehends that in the event no interim directions are passed and only a notice is issued, there is every likelihood that to show compliance of the orders of this court, the petitioner would be dismissed from service, as has been done in several other cases. And this is what has happened today, my lords, with the handing over of these orders. An order of July 2025, my lords, not served on the petitioner. The petitioner who is impacted by the order is not served. She has not even addressed this order, my lord. This order impacts her more than the other officers. Officers are only for, my lord, information. She is not named. Look at the casual manner in which this order has been passed, my lord. I respectfully submit, my lord, that this order, my lord, is in violation of your lordship's judgment of 20th June 2025. Your lordships must, my lord, reinstate, as per the directions, allow them to me to join. Order cannot be flouted like this by a paper compliance, my lord, on the face of it. And the state is, my lord, taking cover of a SLP filed by one other officer. It is not the case that we are not doing because there is a stay up at the Supreme Court. And Supreme Court was very clear, my lords, only qua the appellant, because, my lords, they didn't want, my lords, they saw, my lord, it was a judgment passed in, my lords, 47 appeals. That's why the Supreme Court judgment is very clear, my lord. It's only in writ appeal number 131 of 2020. So her rights, my lords, will be decided by the Supreme Court. The rest, my lord, Supreme Court could have said otherwise that the operation of the judgment is stayed, which they do it in many cases. And, my lords, So, my lords, all I am saying is this, my lords. The state, my lords, the lordships have seen, my lords, how, my lords, a division bench judgment has been dealt with by the state. They have turned the judgment upside down. There is a committee recommendation saying you take orders under 147, and that is what is done, my lords, here. That's on the teeth of your lordship's judgment. May I say this, my lords? My lords, may I say this, subject to meeting your lordship's, my lords, concurrence, is this. This cannot be handed over, my lords, like this to the court. Let an affidavit come, my lords, from the commissioner. Let him place this on record, my lords. This same order which has been handed over today, your lordship will just take note of this order. In the meanwhile, my lords, direct them to, my lords, grant me prayer too. This cannot be done, my lords. Where does the citizen go? And it is not that she is staying in Timbuktu that you can't correspond with her. Her address is there. She is in correspondence with the department. She visits the office. You don't inform her. And then you give a order in a manner like this, my lords. Let that come in an affidavit, my lords, because the officer who filed, my lords, will have to be held up, my lords. Until then, my lords, I am pressing for, my lords, prayer 3, which is at page 20. They can't make a mockery of the judgment of this court, my lords, with due respect. And they are in that, the committee says, file review petitions. 8 months have gone. Where have the reviews gone? They can't play with the rights of citizens like this, my lords. A judgment, my lords, must be given effect to. Is the Goswami Maharaj? Okay, sir.
Right. A. Chaudhary, learned senior counsel, assisted by Ms. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. N. Kohli, learned senior advocate, assisted by
A. Roy and N. Menon.
Mr. A. Roy.
Yes, that's also is.
A. Roy. Mr.
N. Menon, and then
Yes,
Lordship,
that's-
my colleagues in the court are there, they'll give their name.
And Mr. D. Nath, the senior government advocate, and Ms. A. Das, learned.
M. Devi.
I'm sorry, I was
Yes,
always making a
yes.
mistake.
Lordships went to the better half.
Growing old.
No.
Lordship, on that, I have a slightly other thing on a complete light note. Better or bitter is a point of view. And it varies everywhere.
Advocate for the status for the, you're appearing for all the respondents?
Of course, Lordship.
For all the respondents? The learned senior counsel for the petitioner has referred to the observations made in paragraph 4 of the order dated 29/1/2026. And it is submitted that the petitioner appears that in the interim, no interim directions are passed, there is every likelihood that to show compliance of the orders of this court, the petitioner may be dismissed from service, as has been done in other cases. Also, it is submitted that by virtue of the judgment and order passed by this court on 26/2025, passed in a batch of 49 petitions, including your case is WBC.
Read appeal number 14 of 2022.
Including this is 49 or 47 petitions here. It is
Total 47 appealants were before your lordship, that your lordships have recorded.
47 appeals.
47. 49, there were 2 repetitions, so your lordship said, well, effectively there are 47 writ appealants.
47 appellants,
That your lordships will find, my lord, at page 64,
including
para 3,
including WA
14 of 2022.
14 of 2022. Amongst others, had passed the had partly allowed those appeals with the following effective directions. Page 140, 152 onwards, paragraph 140. It is still 154, right? 152 to 154. 140. Next, it is submitted that the court had taken cognizance of the completion of initial probation period of 2 years of all the appellants, including the petitioner, and taking into consideration the maximum extendable probation period under respective service rules, directed reinstatement within a period of 50 days from the date of the judgment and order. Full stop. It is submitted that though the case of the present petitioner falls within the scope and ambit of paragraph 140 within bracket 1 within bracket small Roman 1. The state has considered only the directions contained in paragraph 140 within bracket 1 within bracket 7 Roman 7, and has passed discharge orders against several of the appellants in the said order dated 26/2025. Accordingly, he has created for interim directions as contained in prayer Roman 2 of Roman 3 of this contempt petition. Next part. The per contra, the learned senior counsel for the respondents, through his learned assisting counsel, has produced copy of notification dated, the notification number is there. Notification number shows dated so and so, issued by the Principal Secretary to the Government of Assam from our Transport Department. Project that the petitioner,
followed by the corrigendum, Lordship.
I will put it by which the competent authority in exercise of powers conferred under Rule 19 within bracket 1 and 2 bracket close of the Assam Transport Service Rules, 2003, that discharged the petitioner, district transport officer within bracket probationer, from service with effect from 21/1/2019. And that the discharge order and that the said discharge order was. Mr. Kohli, what is the meaning of this last two lines?
In the discharge or the corrigendum, Lordship?
From service, no, the discharge order from service with effect from 21/1/2019. That is the date of discharge order issued on.
This is the first one, Lordship.
Yes. No, the discharge order.
Lordship, I just explained. Lordship, in para 7, if I may just for a moment, in Roman 7, paragraph 141, Roman 7, Lordships had given a specific direction. So if Lordship would be pleased to reproduce that, this will become clear that if you have issued a discharge order, which is even treated stigmatic, then you have to withdraw that and then issue a fresh subsequent discharge order. That is the point.
It's on the lighter side, your lordship said quash the discharge order.
Accordingly,
141.
the said discharge order number TMV full stop 298/2016/144 was substituted by the current notification dated 11/7/2025, which is submitted, which is stated to be in compliance with the directions contained in paragraph 114 within bracket 1 within bracket 7 of the said order dated 26/2025. It is further submitted that subsequent corrigendum dated 21/7/2025 was also issued to provide that the two notifications referred above shall come into effect from 21/7/2025. It is he has also produced, next one, he has also produced a copy of order dated 10/11/2025 passed by the Supreme Court of India in SLP within bracket C. Numbers S is in comma bracket number within bracket S. Numbers 29588/2025. By which the judgment and order dated 26/2025 passed in writ appeal 131/2020 was stayed. The said order is quoted herein below. It will say. Full stop. Accordingly, it is submitted that as the judgment and order passed by this court is stayed, contempt petition ought not to be proceeded with. And there cannot be a further interim directions for compliance of the judgment and order of this court, correct?
Lordship, yes, that's my, that argument is correct because it's state you can't give effect to it, but that is without prejudice to the fact that effect was given in July.
Next part. Considered the submissions made by both sides. Next paragraph. We take note of the fact that as per the information available in the website of the Supreme Court of India, the appellant before the Supreme Court of India, no, the respondents in the said proceedings of SLP's civil number 29588/2025 before the Supreme Court of India are number 1, State of Assam, within bracket number 2, the Additional Chief Secretary, number 3, the Secretary to the Government, and number 4, Devajit, DEBAJI, Devajit Bora. Full stop. It appears from the copy of the order dated 10/11/2025, passed by the Supreme Court of India, that the stay is made operative in respect of order, judgment and order dated 26/2025, passed in WA 131 of 2020. Full stop. Next para. No, not next one. Continue. You say that thus, the present petitioner in this contempt petition is not found to be a respondent in the said proceedings. Next one. Insofar as the production of the orders dated 11/7/2025 and 21/7/2025, which has been produced before this court, as the court is in session of a contempt petition, and the personal appearance of the respondent contemners have not been exempted, it would be appropriate that the respondents should file their affidavits and take their stand in respect to the contempt petition, and any one of them can bring on record the copies of notification dated 11/7/2025 and 21/7/2025 on record. Full stop.
Does not exist.
The prescription regarding provision and confirmation under the Assam Transport Service Rules, 2003, which is contained in Rule 21 thereof, is quoted below, page 95. Next one. By virtue of directions contained in paragraph 140 within bracket 1 of the order dated 26/2025, the discharge orders in respect of all the appellants were set aside, which was subject to the which is made subject to other directions contained in subparagraph within bracket Roman 1, PO2, Roman 10. Stop. In this case, from the copy of notification dated 11/7/2025, which is produced before this court, the discharge orders, the previous discharge orders were passed on 21/1/2019. Stop. There's no material available at this moment before this court as to how the notification dated 11/7/2025 and the corrigendum dated 21/7/2025 were served on the present petitioner. Stop. This observation is made because the learned senior counsel for the petitioner has emphatically stated that as on date, as per his instructions, the said notification dated 11/7/2025 has not been served on the present petitioner.
She's present here, madam. The petitioner is also here.
Okay, we take note of
Yes,
the
yes.
submissions because we don't have the,
Yes, yes.
we don't know the.
Yes, yes.
We further submits that the petitioner is present in court in this court hall and he has been instructed to that effect. Be that as it be that as it may, though it is seen that the discharge orders of the petitioners were set aside by the interim notification dated 11/7/2025, the discharge orders have been substituted in terms of directions of this court with effect from 21/1/2019. But by effect of the corrigendum dated 21/7/2025, the said notification dated 11/7/2025 is to come to effect from 21/7/2025. Thus, it prima facie appears that the discharge order of 21/1/2019, which has been set aside, has been substituted. In the absence of any affidavit by the respondents, it is not clear as to whether in compliance of the provisions of Rule 21 of the Assam Transport Service Rules, 2003, any order was passed by the competent authority for extending the period of probation in respect of the petitioner. This observation is incidental and not and prima facie not a final finding. And therefore, this observation should not pass. Next paragraph. Under the circumstances, as it is noticed from the contents of the order dated 10/11/2025, passed by the Supreme Court of India, that the stay of the judgment and order of this court dated 26/2025 is only qua writ appeal 131 of 2020, the said order, in the considered opinion of this court, would not extend to WA
14 of 20.
14 of 2022, filed by the petitioner. Next paragraph. Therefore, this court, in order to ensure that there is no continuance of disobedience of the directions of this court, so as to uphold the majesty of this court, is inclined to hold that the respondents are required to first show that they have purged of their contempt, and therefore as the order dated 11/7/2025 produced before this court is relatable to the discharge order of 21/1/2019, the court is inclined to pass an interim order in terms of layer 3 of this writ appeal, directing the respondents of the contenders to permit the petitioner to join our service without prejudice to the defenses which may be available to the respondents in this contempt petition, and to release on service within a period of within a period of 30 days from the date of this order. Next, ma'am. We further clarify that the interim order has been passed by taking into consideration that as the current discharge orders dated discharge order dated 11/7/2025 for police before this court is in substitution of the discharge orders dated 21/1/2018, which has already been set aside, as clearly indicated in paragraph 140 within bracket 1 within bracket small roman 1 of the order dated 26/2025, the said discharge order, this said modified discharge order read with the corrigendum dated 21/7/2025 would not denude the authority of this court to issue such interim directions so as to compel compliance of the orders under contempt. As the order is passed in the presence of the respondents, the instructing counsel for the senior counsel for the respondents, the order is deemed to be in their notice, nonetheless, in addition to the team notice of the respondents of this order, the petitioner shall also produce a copy of this, the certified copy of this order before the respondent number two, it constitutes due notice to all the respondents. Next paragraph. List the matter after 30 days. Let's just say that in the meantime, we hope and trust that as the personal appearance of the respondents has not been dispensed with, the respondent would file their affidavits by next date of listing, heading which the court would have no option but to insist on the personal appearance of the respondents. Most of the personal appearance of the respondents are dispensed with on the next date of listing. Next list on.
Lordship, I have a few things if Lordship would permit me.
Yes.
One is Lordship subject to correction, because there were two things that Lordship, I was not sure if I heard them correctly. One is Lordship, I was just pointing out that the order of discharge of 11th July 2025 was the fresh discharge order. The corrigendum which came does not relate to 2019. It only basically kept in abeyance 11th July till the 30-day period of Lordship's order had elapsed. So therefore, that was the first point. I may not have heard it correctly. I just thought I'll again repeat it. Second, Lordship, my argument, I don't know if it was attributed to me or to Mr. Chaudhary. I had said on a without prejudice, assume if it is not served also, then it would not lie in contempt. That's a separate proceeding, but I was not sure if Lordship was attributing to me that argument to Mr. Chaudhary. And the third is a request, subject to what Lordship feels, is that Lordship may keep it after 3, 4 days, 5 days or a week, because then we bring our affidavit and then pass a direction which is in the nature of a final direction. But I'm in your hands. These were the three things.
You can always file an application to modify the order.
Yes.
File an affidavit and file that. But this observation I'll record. The second observation, I am not sure, I cannot recollect the declaration right now.
Exactly, Lordship. Even I didn't hear it clearly. That's why I said, Lordship, when you're seeing the order.
That first submission I'll record. Next paragraph, before you say, at this stage, the Learned City Council for the respondents has submitted that his submission was to the effect that the order dated 11/7/2025, from a copy of which has been produced before this court today, was a fresh discharge order and independent of the previous discharge order. Correct?
It is no, it is actually, Lordship, I'm not saying it's independent. It is in effect of Lordship's order. And if the petitioners are praying that in anything on service, then that is not going to be part of the contempt jurisdiction.
No, you have said that this is 11/7/2025 was a fresh discharge order. That is what.
Yes, Lordship, absolutely. It's a fresh discharge order, absolutely. In compliance of para 141.
No, that's what we have recorded.
Yes, yes.
Right now. Please repeat that, what was recorded, last slide. It is fresh discharge order independent of the earlier order.
No, Lordship. May
No,
just record. Lordship,
fresh order. Okay.
it's a fresh order in compliance of 141(7).
First order in compliance with 141(1)(7).
Exactly, Lordship. And the corrigendum of 21(7) is merely keeping this in abeyance.
That we have recorded.
Just one suggestion development. The Lordship have said to serve a copy on respondent number 2, the commissioner. And she will report to the commissioner in terms of this order. Lordship said.
I'm saying we are saying 30 days. We have our own reasons to give that.
Lordship, can I make a request on the date? Is it possible to do it on the 26th instead of 23rd, Lordship?
26 is what they.
26th.
26. Or, because my learned colleague who's briefing me, Lordship, he's not available till 25th.
No, it's okay. It's okay. Date is 20.
26.
26. Thursday. April.
March.
March, Lordship.
Okay. 26.
I'm grateful, Lordship.
Very grateful for a patient here. Great, sir. Thank you.
But all other matters we'll have to adjourn.
I'm very sorry, my lord.
Will not be able to take up other matters. There were 2 or 3 requests to update
Lordship.
and take yours is a parted matter.
Yes, your lordship. Can
How
it be
much-
taken can it be,
How
my
much time
paper
will
can
you
be
take?
taken?
How much time will you take? Just a moment.
Hello, can it be taken next week, subject to your lordship's convenience?
Suggest a date.
Tuesday. Tuesday.
My lord, actually,
Just a moment.
24.
This is a parted matter.
24.
Is going since yesterday.
Yes.
24, lordship.
24. Oh, special. 5, 24. This is item number
52.
52. This matter was a matter which was heard in part on 17/2/2026 and was kept today for further hearing. So however, for paucity of time, the matter could not be heard today. Next matter is agreed to by both sides. This the matter, this as a parted matter on 24/2026.
Deeply privileged.
Lordship, item number 36, may I have for listing day after tomorrow? If
36.
that's the only one order is required, basically, because IA is there.
What is this IA for?
IA for praying for leave of these unable to file implement petition. Because we are being affected party, we are not bad party in the petition.
Who is the respondents here?
Here, respondents is one private also is there, but the petitioner is petitioner is appearing.
You can allow the application or you have
Yes.
objection?
I want to file an objection. My learned friend is asking for listing it day after tomorrow, lordship. Because
No,
otherwise,
if it is for implementing, we'll pass orders right now. We don't wait for 2 days.
Need a leave.
Just show that right. Yes, Mr. Goswami.
Item 43, lordship. Delay in filing appeal, only notice will go, lordship.
Item 43.
43.
Notice a delay of how much?
Delay of 170, 120 days,
128
days.
days.
We have already served the copy.
Elementary Education Department is available.
Oh.
IA. 43. Mr. S.K. Goswami, that is counsel for the applicant. BTC, somebody is there? No.
Lordship,
He
was here, lordship. I will inform.
Who was available?
Bernally was available, lordship.
He will be outside, I think. Just.
Lordship, I have seen.
There.
Lordship, I will call.
As well as Ms. B. Chaudhary, Lahore. C. Chaudhary, isn't it? Item number 3, B. Chaudhary, Lahore. Study was for the PTC. By filing this interlocutory application, the applicants are seeking condonation of delay of 128 days beyond the period of limitation in filing by expiry local notice. Give it. The take steps for service of notice on private respondents within 2 days. Next. List of first. 18th of March. This item 44 is what?
Obliged.
Item 44. Nobody is there.
Lordship,
Item 45. Mr. Nath was here. What is this application for?
55.
Please ask if this IS will issue, if it is to be issue notice, we will do it. And let us see this order. The filing, artist 36.
Lordship, if I may, Lordship. Item number 33, Lordship, the fresh admission matter came up for the first time today, Lordship. We are for the appeal and there's some urgency on our part, Lordship. Can this matter be taken up on Friday, your Lordship?
Just a.
Lordship. Okay.
Yes, sir. Respondent number 6 is branch manager, Indian Bank. Notice has not been served. We can't allow this application.
Union Bank?
No, this is branch manager, Indian Bank.
No.
Respondent number 6. Service is not complete.
No, this is with regard to the, this writ appeal law. So this, another application has been filed with regard to the fact that there was a probability of disbursement of the amount. So he filed one IA with regard to the disbursement of the amount, and he has filed one application for implement.
There is 3763,
There's a
madam.
defined IA which has been filed.
This
But otherwise we won't-
leave application 3763.
Leave.
It's a leave application lawsuit for including this applicant as a party to the proceedings.
You're not a party in the.
Oh, no, I don't. I was not the advisor, I'm now affected party.
Okay, heard. Mr. C. Barwa, done at counsel for the applicant. Also
Applicant.
heard Mr. S.P. Chaudhary, done at counsel for the respondent. Numbers 1 to 4.
Yes.
Were the appellants in the conduct appeal.
Yes.
Next.
I am appealing for respondent number 7.
As well as Mr. S.K. Hazarika, done at government advocate, appealing respondent number
7 and 8.
Respondent number 5.
Next one.
5, 6, 7 and 8.
No.
5 to 8.
5 blocks and border.
5 is N Bortoloi. So 5 is Miss N Bortoloi. Learned counsel for standing counsel for revenue and disaster management department. Mr. S.K. Hazarika, government advocate for respondent for 6, 7 and 8. 9, Pranab Kalita, who's appearing for his.
No.
Was. By filing this interlocutory application, the applicant is waiving leave of this court to file an implement petition. This time it is projected that without completing the applicants who are proper and necessary parties, who were part of who are proper and necessary parties in the writ petition, were not completed, and therefore they are agreed by the order which is put to challenge in the connected WA 299 of 2025. Next one. Although the learned counsel for the respondent numbers 1 to 4 have objected to the application, but taking into consideration the grievance raised by the applicants, the leave petition stands allowed. By granting leave to the applicants to file an impeding application in the connected WA 299 of 2025, next para. This equivalent application stands allowed and disposed of.
Can a date be fixed? No.
No, it's
No,
more.
because we are- This also, they will file an application.
Then only.
We are not touching that writ appeal.
Yes.
In writ appeal, we are not passing any orders. The mention before the.
May please, your lordship. I declare item number 40, my lord.
Lordship, item number 33, your lordship. With regard to a selection process, lordship, for the post of a teacher in Sanskrit of Nalbari College, your lordship. We have some urgency, lordship, we are for the appellants, your lordship.
I am for the KVA, my lord, in this case.
So, we are not passing any orders. We are asking about.
For Friday, your lordship.
It's a fresh matter.
Fresh
Yes,
matter.
okay. Okay. Will be able to-
Lordship. Obliged, Lord.
Obliged.
Which is a representative.
My lord.
The, Mr. Aram, Mr. N. For the appellant submits that there is some urgency in the matter. During possibly time, the matter could not be taken up to place. But if Mr. N. Gautam, then counsel for the appellant submit that there is emergency in the matter. Accordingly, list the matter in the admission column on the after tomorrow, Friday.
28th, Lordship.
Tuesday. 2/10/26.
Lordship.
Obliged. May please your lordship.
Yes.
Item number 40, my lord. I have filed for correction of the necessary order, my lord.
40.
The Superintendent of Police, Shunitpur, my lord. My lord, the Superintendent of Police order, Vishwanath, should be there.
Let me read the report out.
Okay.
ये 37 too late was. RT7 too late was.
You kindly see page 9, my lord. The superintendent of police border, Sunitpur, Tezpur, within 10 days from today, during the office hours, there should be, my lord, superintendent of police border, Vishwanath, my lord. In other places also, my lord. The line number
মোটো আছে নি স্যার নাই নাই অকল দেখা দুটো ভোট হেৰি আছে কৈ দিম একো নাই এগ্ৰিমেণ্ট ফাইভ জেগাত এপ হৈ আছে cannot be by not word for নাই মানে আৰু এইটো লগে ফোর In item number 37, there's some minor typographical errors are there also. 37 to 50. In paragraph 3, 4, and 7 of the order, exhibit 5 has been typed out in place of exhibit F. I am sorry, Your Lordship, to disturb at this moment. Okay. In paragraph 3, 4, and 7 of the order, exhibit 5 has been typed out in place of exhibit F. 5 has been typed out in place of exhibit F. And Lordship, in paragraph 7, Lordship has given me a liberty. Lordship has stated that shall be a bar. It is reflected that shall be a bar, not what is missing, Lordship. Lordship has actually given me a liberty by that order. That earlier rejection of earlier order shall not be a bar. That not what is missing. Lordship. It is written as typed as shall be a bar. In the first, second, third line of paragraph 7.
This is reflected as shall be a bar. That much, Lord. So we have filed it, but I could not get it listed also.
When did petition, where is that? Exhibit F? Which page?
In the prayer itself, it is reflected.
No, that's okay, but where is that document?
Documents. I'll show you. Document is a lordship and affidavit lordship. It is reflected in the order itself.
No, that's okay, but where is the document?
At page 67.
67.
By that affidavit, the father of the applicant has changed his title. In the prayer lordship, it is reflected page 10 lordship. In prayer of my repetition lordship.
Heard Mr. M. Mohanford, I'm counsel for the applicant. CGC.
Is there? Page is not present also.
Who's it? So Mr. A. Gayan learned at CGC and Mr. H. K. Hazarika learned. Government advocate, Mr. G. Sharma, learned standing counsel for the FT and border matters. And for ECI, Election Commission. For Election Commission was there, Mr. Kataki. And Ms. S. Kataki, learned standing counsel for the ECI. Next para. By
This case number 2162 of 2000. I number 2162.
no, where is this? There is this petition dated 19/3/25.
19/3/25. That is at page 80 of the my petition.
80.
80. That is impugned order. Before that, we are page 71. That is the petition. Order is at page 80. Order is at page 80.
Next one. By filing this interlocutory application, comment is submitted that typing error has occurred in paragraph 3,
4 and 7.
3, 4 and 7 of the order dated 13/6/2025. And
exhibit.
And instead of exhibit F, comma, reference is made to exhibit 5.
Yes.
First of it is also submitted that
in third line of
paragraph
7.
In paragraph 7 of the said order, comma, the court granted leave to the petitioner to move an appropriate application in respect of exhibit F, affidavit, F, comma, affidavit. First of, however, there is an omission of the word, inverted commas, not in the said directions, which has changed the context of the leave given in paragraphs, in the said paragraph 7 of the order. Next one. Having seen exhibit, annexes 6 to the connected writ petition, IWBC 3177 of 2025, it is seen that there is an error in typing in the error of typing as pointed out. Next paragraph, accordingly, the reference to exhibit 5, appearing in paragraph 3, 4, and 7 in the order dated 13/6/2025, passed in WBC 3177 or 2025, shall now be read as exhibit F. Stop. Moreover, by next paragraph, as the omission of the word inverted commas not is apparent in paragraph 7 of the said order, the recast paragraph 7 of the order dated 13/6/2025 shall now read as follows. This page 10. Here I have written the word not by hand. Just copy that. Page 10, paragraph 7. Not within self, not by hand. It took not by hand. Next paragraph. Accordingly, this interlocutory application stands allowed and disposed of. Next paragraph. This order shall be read together with order dated 13/6/2025, passed by this court in WBC 3177 of 2025.
Much of it. That have changed the entire order.
You came too late.
I have filed the application like.
May I please, Your Lordship? Look, item 23, if possible, my lord, next week, my lord, FT matter, my lord. Item 23, or first week of March, my lord.
Did you? Order.
Developers.